My lord, I am praying, my lord, kindly, my lord, in the Monday, my lord, kindly fix the, my lord, to be in the upgraded
Item number
377.
item number 377. Nowadays, that is available in the website. Who is entered appearance?
My lord, not yet, my lord, nobody, my lord, the file vocal, my lord.
এটা to be mentioned করে দিন সোমবার.
Get me.
Yes. Call the list.
Number one.
Okay. Ashun. It has been pointed out that prosecution. Yes, you are appearing.
Item two, my lord.
Item 2, yes.
Yes, yes. Sorry. Madam, praying for withdrawal for non-prosecution.
On prosecution. The learned advocate appearing for the petition submitted.
My lord, I am appearing for the, there will be some correction, my lord, in the cost title.
What's that?
I shall correct the cost title in course of the day, my lord.
You have not corrected.
My lord?
You have not corrected.
Yes, my lord. I missed,
Please correct that.
yes, my lord.
No order is necessary. Permission, leave was given. Please correct the cost title.
Yes.
Yes, next.
Right, my lord.
Item number four.
My lord, this has come up at my instance, my lord, for two things, my lord. One is, my lord, the correction is required. The date, my lord, the year of the suit is incorrectly mentioned, my lord. Instead of 2003, it will be 2023. And my lord, extension will extension.
Extension.
Yes.
Have you served?
Yes, my lord, the service is there.
Received. Ashun, it has been pointed out that there is a typographical.
On behalf of the petitioner, my lord, pursuant to my lord's order,
Notice was sent to the opposite party, but it has been returned back with the postal endorsement that she is
Right
deceased.
to be mentioned.
My lord, she is deceased, but I found from the certified copy which was obtained subsequently that the deceased was died long before, and she was already substituted. The name of the opposite party should be changed, my lord.
Name of the opposite. So you have filed against a dead person.
Against-
Died. Nilima Bandhu died.
Nilima Bantu died.
So you have to take out an appropriate application.
My lord, kindly grant me such leave so that I can file that application.
For that, leave is not necessary. The learned advocate appearing for the petitioner submits that
Paying for non-prosecution.
non-prosecution. Where is the letter?
My lord, yes, I have
The
already.
learned advocate appearing for the petition.
Year of the application mentioned in the order reads 2024 instead of 2025. I'm praying for correction to that effect, Your Lordship.
It has been pointed out that there is a typographical error.
I'm for the petitioner, my lord. I'm here for the correction of the previous order.
Yes, what is the correction? Costatl.
Yes.
It has been pointed out that there is
came up itself, my lord, for correction. No, I think the opposite party's spelling is wrongly recorded.
Ashun, it has been pointed out that
Lordship, I am acting on behalf of
Matter
KHC
happened
Lordship.
yesterday regarding that.
yes.
Lordship,
Mujumdar-
Mr. Ghosh and Gopal Chandra Das both are engaged in court number 18-1 contempt matter is going on, Lordship.
Yes.
Kindly make it 12, Lordship.
Start. They will be coming. And you are here, yes. Call them.
Impugned order,
Yes.
page 36. This is the order challenging by which we have come before this court, my lord. And kindly come to page.
Show me the order passed by the special officer building. Huh? Show me the order passed by the special officer building.
Special officer building.
Yes.
এই ছবিটা কোথায় আছে? না order. Four.
124.
Yes, my lord. This is an order passed by the tribunal.
Mr. Mujumdar, please first take me to the order of this.
Yes,
SOB.
sir.
SOB.
Yes.
Special officer building.
Page 72.
72. Yes.
This is the order which contains a certificate of application. Detail of unauthorized construction, so and so, the change of use of beyond sanction plan.
What is your name? Dulal Chakraborty.
My lord, this proceeding was brought against Dulal Chakraborty.
You are Bapi Chakraborty. What is the relation between Dulal and Bapi?
What is the relation? Co-owners, brothers, but not own brothers. But they are the cousins actually, but they are the co-owners.
Yes. So
Seeing
it's Dulal Chakraborty and others. So all the owners were made persons responsible.
এর মধ্যে পার্টি ছিল কোনটাতে? এই দুলাল চক্রবর্তী জানি না। 2/1 Daudar so and so, violating rules 80, 62, 78, 133, 134, relevant record or information available with the plan, file, demolition sketch, deed of conveyance, precise infringement statement from Borough Office are taken up for consideration. A notice under section 400 subsection 1 issued on 26/11/2021 as per report of concerning Borough. There is a complainant named Tutul Chakraborty. As per report of the from concerning Borough, infringement statement of building room so and so. But this is the report. Total unauthorized construction is so and so. Change of area of change of use 204. The flat owners lodged complaint. May I just point it out for your lordship's kind consideration?
It's an internal dispute.
It's an internal dispute. And your lordship would be stunned to know that this building.
What have you done, Mr. Mujumdar, which resulted in this internal dispute?
I am nothing, my lord. The internal.
You must have done something
nothing,
for
my lord,
which.
nothing. I tell you, lordship, if your lordship would be stunned to know, or would be astounded to note that the sanctioned building plan was valid till 2014. 2014. There is no CC for the building.
There is no CC?
Yes, there is no CC. As an officer of the court, it is my duty to point out whatever is there on record. There is no CC for the building. So, my lord, this concept of.
So you are the owner, or you were the original owners?
We are the original owner of the land. And yes, we are original owners and also part.
You entered into the development agreement.
But abandon the project.
Yes. So now you are in occupation of the owner's allocation.
Right.
Developer's allocation as
Well, we purchase the developer's allocation so far as the disputed party is concerned.
you also purchase the developer's allocation. Now, these flat owners are within which allocation? Developer's allocation.
They are
The flat owners are in their own, the owners allocation.
owners.
But the allocation has not.
You have transferred.
There is no question of transfer, nothing.
Totally entered into it.
They have entered into the premises. Let us be very clear, my lord. The owners, my lord, there was
You are the original owners of the property.
yes, my lord. Once
You entered into a development agreement.
a shell apartment was made ready, they entered into the premises and occupied there. My lord, there was a development agreement. Suppose in the development agreement, on one floor there are two flats. Flats were identified, so they entered into their respective
Accordingly, without any.
portions without there being any formal deed of conveyance or any formal string of documents. Well, so far as the portion which is now under dispute, which is subject matter of the demolition, this is part of the, my lord, the ground floor.
Only the ground floor.
Yes, only the ground floor. Ground floor, my lord, which I am using as a commercial space. I have to state whatever is there, using as commercial space. So your lordship will find the allegation is that some internal walls have been constructed on that ground floor, and it is being used for commercial space. That is all.
But the sanction was for residential.
Sanction was for residential, and the sanction is no longer valid.
No, the sanction was for residential,
Yes.
illegally converted to commercial.
No. Well, this is about garage space. This is about the ground floor. Ground floor was never residential. Ground floor was never
There are two
residential.
things. If the property is for residential use,
Yes.
so per flat they have a ratio that you
Well, I
have
tell
to
you, lordship,
have the
Yes,
such
yes,
number of minimum
I
number.
tell you, lordship, well,
garage
one thing
space.
more. I must indicate to your lordship, there is another store, another automobile store. Key store আছে ওটা?
Yes,
TVS mobile store, which is occupying part of the first floor and the ground floor.
Yes. So what was the sanction? Was it for the entire residential use?
তাই ছিল? প্রথম স্যাংশনটা কিসের জন্য ছিল বলো? The ground floor was meant for car parking. Your lordship knows that this is the general sanction which is given.
Yes.
The car parking space is actually, my lord, is relatable to the units of the tenements.
Yes, has to be.
But there is no unit or tenement as such, because as of date there is no sanction plan or CC.
Yes.
Well, a sanction plan once expired and once it is
No,
not
in the
renewed.
sanction plan, Mr. Mojumdar, they will say that such number of garage space. These are the number of flats.
2016 the sanction plan expired.
No, maybe, but in the sanction plan,
Yes, that is
has
there.
to indicate that these are the number of garage spaces.
Absolutely, in the sanction
So
plan.
what is the violation? So you have increased the number of garage spaces.
No. Matlab, we have purchased the garage space from the developer. We are using it for commercial purpose. I am very clear.
Commercial means converted to shop rooms.
Yes. Internal walls have been constructed. This is, may I just indicate to your lordship, this is when we take the Lake Garden flyover leading to, my lord, towards, my lord, Prince Anvasha Road. Once we, my lord, disembark from the flyover, get down from the flyover, it is a building which can be seen from that on the left hand side. But the lordship will find this is a shabby building which without any exterior paint, because it was never completed. And all the owners.
Now, Mr. Mojumdar, the difficulty is,
Yes.
if the building do not have a completion certificate, you cannot use that same.
Nobody can use.
Nobody.
Nobody can use.
Nobody can use
be
the same.
adjudicated by tribunal. Let it be adjudicated by tribunal. But I have a remedy. I have tried to avail of the remedy. The matter went up to the Honorable Division Bench. Honorable Division Bench granted me leave to prefer appeal without certified copy.
SOP's order was challenged before the writ court first.
No, SOP's, my lord, the private respondents, well, I mean this, whatever his name, Tutul Chakraborty filed a writ petition.
He is also related to you.
Yes.
The surname says so.
He is also owner, I am also owner. Tutul Chakraborty, who is my relative, he filed a writ petition.
and for implementation of the demolition or for execution of demolition.
So for implementation of SOB's order.
Yes, SOD order. This order admittedly was not communicated to me. The first time we came to know about this order when the writ petition was moved, and my lord, these materials were disclosed during the course of hearing of the writ petition. Then, my lord, I preferred an intra-court appeal. Why? When the intra-court appeal was being heard by the Honorable Division Bench, the Honorable Division Bench directed us that you prefer appeal. Without certified copy, even if the certified copy is not available, prefer appeal. I am granting you that leave. Pursuant to the leave granted by the Honorable Division Bench, on 11th November 2024, I
Can you
preferred.
show me the order of the Honorable Division?
Yes, certainly. Absolutely, my lord. Paste it down. আমারটা এক সেকেন্ড মানে kindly give me a second, my lord.
Yes. Is it page 60?
Page?
Is it page 60?
Yes, yes, yes.
দুটো অর্ডার আছে।
Learned, first kindly take page 60. Annexure J. Learned advocate.
Now, yes, page 60 is the order.
Yes.
Paragraph 5 is the relevant paragraph.
My lord,
Which
kindly
we try to rely upon.
Paragraph 5.
So after that,
My lord, did not receive a certified copy, received a certified
so
copy.
you are relying upon paragraph 5 of the Honorable Division Bench order. Yes, 4 permitative, 5 says,
My lord, my case.
now pursuant to this,
We
you
prefer.
approached
Yes.
with a section 5.
Yes.
Why did you file section 5?
My lord, when I filed section 5 along with the appeal,
That was rejected.
that is the subject matter of challenge.
That has been rejected.
Yes.
Show me the finding of the tribunal with regard to rejection of section 5.
Yes, my lord. Kindly take the impugned order.
You need not place the entirety. Please show me that portion with regard to what is the ground for rejection of section 5.
Yes, my lord. Kindly take for once.
This 7-page order for section 5.
My lord, what is relevant? First, kindly take
7-page order for section 5.
36, page 36.
No, I have the certified copy at the last.
My lord, kindly take internal before I take. Yes, internal page 4.
So, Mr. Mujumdar, 7-page judgment for rejection of section 5.
Yes, yes. With costs. And my lord, your lordship, I will tell your lordship, my lord, what has happened. Kindly take page 4 first. Internal page 4.
Yes.
My lord, I must take your lordship to first 2 or 3 paragraphs. Hearing arose in respect of application and
Page 4. Which paragraph you have placed?
this is first page.
Oh,
এখানে
first
page,
page.
এখানে first page কেন?
Page 4 of internal page এটা।
মানে first page, my lord,
Yes, first page. Yes, hearing arose.
hearing arose in respect of the application under section 5 of Limitation Act. Appellant filed the instant application praying for condonation of delay of 454 days. The appellant filed photocopy of documents in support of the instant application. No written objection was filed against the instant application on behalf of the respondent KMC. Private respondent number 567 filed written objection along with photocopy of some documents against the said application. Pausing here for a moment. Against the said written objection, we filed an affidavit in reply.
That was not considered.
That was not considered.
Yes.
And that we had filed affidavit in reply would be evident from the order at page 124. It has been taken on record.
Yes.
Now, my lord, may I take your lordship? The contention of the appellant is that in the instant application, the impugned order was passed on 15th December 2022 and this appeal has been filed on 12th November 2024. On receiving copy of the writ petition, being WPA number so and so, the appellant came to know about regarding the impugned order, but the appellant was not served of copy of the impugned order. As such, the appellant served a letter to the learned advocate for private respondent requesting him to supply copy of the documents. Upon receiving the entire copy of the documents, the appellant came to know for the first time the special officer building has passed this order of demolition. Immediately, the appellant contacted his learned advocate to approach this tribunal challenging the impugned order dated 5th December 2024. The appellant's further contention is that the appellant was never served any notice under 400 subsection 1 416 of KMC Act with respect to hearing dated 4/11/2022. The appellant was kept in the dark and was prevented from making his representation before the special officer building. There is a delay of 454 days in filing the instant appeal. There is no intentional laches or negligence on the part of the appellant. The aforesaid 454 days be condoned. Delay of 454 days be condoned. Otherwise, the appellant will suffer irreparable loss and injury. Then, my lord, the written objection is taken note of. The appellant made appearance in the writ petition. My lord, may I just take your lordship, and this is all about the order. But it is also noted, had appeal before the tribunal, further is that the appellant has failed to furnish sufficient cause for long delay of so and so for filing 8688 days for filing the present appeal. Instant application is liable to be rejected. Then, my lord, the submissions are noted. Then, my lord, our findings start at page, internal page 4. In order to appreciate the contention, we have perused the application, annexure thereto, written objection filed by the private respondent, annexure thereto, case record of the instant appeal and case record of the demolition proceeding. My lord, affidavit in reply not considered.
Yes.
Then, my lord, at the outset from the case record, demolition is one of the persons responsible for unauthorized construction. Accordingly, the one Dulal Chakraborty, Bapi Chakraborty, that is the petitioner before your lordship.
Mr. Majumdar, only one without
Yes, yes,
interrupting you. The appeal was filed on the basis of the copy of the order which was annexed to the writ petition, or the
Yes.
certified copy.
Yes, not the certified copy. Certified copy
Which was annexed with the copy of the writ petition.
Absolutely.
Yes, yes.
Yes, ma'am. Amply clear that this appellant along with the other person responsible attended the demolition proceeding on different dates. The matter was heard on 4/11/2022 and the impugned order was passed on 5th December 2022. The appellant ought to have exercised due diligence to collect the information regarding the passing of the impugned order. Order was never communicated. If the appellant has not produced a single scrap of document to show that he made any inquiry or made correspondence with the concerned authority to collect information about the fate of the proceeding which was heard on 4th November 2022. Due to non-implementation of the order of demolition passed on 5th December 2022, the complainant named Tutul Chakraborty preferred writ petition being WPA number so and so before the Honorable High Court for implementation of the aforesaid order dated 5th December 2022. It is admitted fact on the part of the appellant that he received or copy of the annexure in connection with WPA number 5225 of 2024 6th March and got knowledge of the impugned order of demolition. If the plea of the appellant that he got knowledge of the impugned order on demolition is accepted, the appellant ought to have filed the appeal within 30 days within 5th April 2024. No appeal is allowed to be presented without certified copy. Your lordship may be aware, my lord, no appeal is allowed to be presented before the tribunal without certified copy. Then, my lord, will ventilate his grievance and pointing out neither in para 20 or subsequent para of the instant application has furnished any reason whatsoever for not preferring appeal within the prescribed period of 30 days from the date of knowledge of dated 6th March 2024. The averment made in para 10 are incorrect and misleading that the appellant did not file the appeal immediately. Contrarily, he slept over the matter and filed the appeal before this tribunal on 12th November 2024 after delay of more than 7 months. There is no explanation whatsoever in the four corners of the instant application for the long delay of more than 7 months in filing the appeal. Section 5, all the Section 5 Object of Limitation Act, catena of decisions, sufficient cause, etc., etc. Conclusion is at page 7.
So this 7 months delay is being computed from the
Date of
copy of
knowledge,
the
date of
writ
knowledge.
petition, service of the writ
Yes,
petition.
yes, yes. But my lord, what is most important, kindly take, my lord, for once, kindly take page 57 for once. Huh?
Yes.
57.
No, 54. Kindly take page 54 for once first.
This is your RTI application.
Yes, my lord, this is my RTI application.
What is the reply?
Yes, the reply is very interesting. Kindly take, my lord, page 57. Kindly take, my lord, the questions and the serial answers. My lord, question number 1.
57 is the answer.
Yes, 57 is the answer.
Serial number 3.
Yes, yes. My lord, kindly take what was the question. As question was that if any conclusive or final order have been passed, kindly provide me with the certified copy of the same. This was my question. Serial number 3. Serial number 3. And kindly now, my lord, take serial number, the answer to serial number 3.
Awaiting approval.
Yes. This order did not attain finality till, my lord, date of supply of certified copy. There is, in my respectful submission, there is no delay at all. It is an application for delay has been made, condonation of delay has been made, ex abundanti cautela. Nothing more.
They did not approach you beforehand, before filing the appeal before the municipal tribunal. They have approached you late.
Me?
Yes, you. Particularly Mr. Mujumdar. I'm not saying the petitioner's advocate on record. They have approached Mr. Mujumdar at a late stage.
Well, there is a judgment, which is classical judgment of Calcutta. Bar karo. Where, my lord, order when not communicated and what is the consequences. And my lord, this fact was brought on record, this RTA application.
So, Mujumdar, only one thing, do you have the tribunal rules with regard to this filing?
Tribunal rules are changed.
Page 57 circular.
My lord, your lordship is referring to
Mr.
which-
Ghosh, there is a tribunal rules are there for the purpose of filing this application. Do you have a copy of the tribunal rules?
Right now, it is not with me, and also, my lord, I will request your lordship to take it in the next week, because certain orders I find, my lord, this petitioner will move on what reasons, my lord, is civil division case was also filed a CO order. There are certain orders are there. I am to be, got all the information because the proceedings are one after another, my lord, started. What is the outcome of this? Because it is not one way it could not be looked into. The Section 5 application is dismissed or not. Those things are to be looked into because those facts are not here.
This was a regarding perjury procedure. As I pointed out yesterday itself, this has nothing to do with this matter, this order, the order impugned.
No, I think if I correctly recollect, yes, now the name, but after seeing this order, I think there was an order, some documents, some letter for regularization.
Right.
That
But
they have submitted a letter or a prayer
Petition for regularization.
in the writ petition for regularization. They have also filed. Prior to that, the issue was that they have given a letter for regularization before the SOB. Now they have disputed that.
Yes.
According to them, if I correctly recollect that
And
fact,
my lord,
so they disputed that.
Yes.
They said, no, it's not our, that petition was not filed by me. So now, from some order, they approached the SOB passed an order. From that, they wanted some contempt proceedings to be drawn and other things. And I think it was rejected with cost and other things, production of the records. I think those were the issues in that civil division application. They also filed a writ petition, as we have correctly said, for regularization. Now, I think during the course of this civil division application, they had withdrawn or they undertook to withdraw. They undertook to withdraw that.
The demolition order.
So that is one thing. Now here is an issue with regard to section 5.
Well, I don't know, my lord, if the petition is filed for regularization and ultimately it was withdrawn, keeping nothing, my lord, on record regarding regularization, then, my lord, of
No,
course, my lord,
Mr. Ghosh, yes, you are right. Those are on merits. Those are on merits. Whether
now,
they are
those are on
entirely-
merits, my lord, when the appeal has been prepared, and when the question of, my lord, the limitation issue is coming, and the main reasons for preparing an appeal is on that issue.
Only one thing,
But there is no difference in it.
Mr. Ghosh, there are two things. One is they have challenged an order passed by the special officer building before the municipal building tribunal. Now, according to their own showing, since they have applied under section 5, so there was a delay. Now, the order impugned is rejecting the prayer for delay or the prayer for condonation of delay. That's the scope of this civil division application.
Of course.
I cannot go into the merits.
That's right,
Whether
sir. That's
the SOB's order will be ultimately set aside or affirmed on the basis of submissions that they paid for regularization and other things, those are on merits. Those cannot be touched now.
That's the
Only with regard to
Madam.
section 5, only my short question, Mr. Ghosh, to you is, do you have a copy of the Municipal Building Tribunal rules.
There right now it is not with me.
I think it's taxation rules also. I think it's taxation rules also. देखिए municipal building rules है. Taxation rules तो देखिए. It is in which book?
My lord is inquiring about the rule, inquiring about.
Procedure with regard to filing of an appeal before the Municipal Building Tribunal.
I tell you, Lordship, my lord, I had the one occasion to look into that issue, and I also, my lord, made.
I also had an occasion to deliver a judgment on that point.
If on urgent basis, as we do in our court, my lord, that on urgent basis, even the appeal could be preferred without even on that, my lord. That
is the urgent basis. That's a different thing altogether. The usual procedure is with the certified copy. Usual procedure is with the certified copy.
Well, here in this case, my lord, it cannot be considered regarding the certified copy
because
the court has, my lord, permitted.
Yes. Now my short question to you is whether after this order passed by the Honorable Division Bench at page 60, whether it was at all necessary to file an application for condonation of delay.
Well, that might be an issue for consideration by a lordship. Of course, my lord, I also, my lord, yesterday while my lord going through the papers, I have examined that. But the thing is,
that is the only. I'm directing the appeal to be disposed of on.
Yes.
I direct the appeal to be disposed of on merits and points.
Kindly refer to the division bench order, my lord. My lord, without entering into the dispute as to whether the appellant received.
Sir, I will come back to you. I will not pass any order without hearing you. Be assured. Please take your seat. Yes, Mr. Ghosh.
I have also considering yesterday.
Yes.
The paper that Yolos is considering the whether after the order being passed by the
whether they were at all necessary. That is why I asked Mr. Mojumdar.
Theoretically sees the word which has been used, but
yes.
That theoretically considered, of course, it is an interpretation of the order of the division bench.
Yes.
And that interpretation,
Page 60.
Page 60. If you read paragraph 4 and 5 of the order conjointly.
Paragraph says, in the event appeal is preferred by the appellant in terms of this order, building tribunal is requested to treat such appeal as filed in accordance with law. Filing, my lord, is a process that it has been filed. But filing, my lord, permanent actually registration of the appeal, that is to be made subject to, my lord, the condition of delay party is concerned. But filing is one aspect of that. We also used to file the appeal in our court also. That subsequently with an application for section 5. Therefore, one way he could say that I have not obtained the certified copy. That is the reason I'm not able to file the appeal. Then the court said that even without the certified copy, somebody prefers an appeal that may be treated as an appeal in accordance with law.
Yes. This expression, Mr. Ghosh, this expression is very important. It has some relevance. He is requested to treat such appeal as filed in accordance with law.
I'm accepting. The tribunal is accepting and it is in accordance with law without having the certified copy. Without accompanying the certified copy, it is treated in accordance with law. It's an appeal is in accordance with law. Question, my lord, whether this appeal to be, my lord, procedural for final hearing. Subject to, of course, my lord, the condonation of delay. That is, my lord, the consideration of the learned tribunal. Yeah, I'm accepting. Otherwise, I could not accept the appeal at all in accordance with law.
So, according to you, even if the appeal is filed in terms of the Honorable Division Bench order, condonation is necessary.
Otherwise, the court could have said. Naturally, the court also sometimes say that the delay may not be taken into consideration or delay to be considered that as accepted, not whatever way the court says. But here in this case, the court has granted that the situation that without the certified copy, he could prefer an appeal. Yes, prefer an appeal.
Right to file appeal.
And right of the appeal, my lord, has been accepted by the office. Tribunal has taken another one. And they have rightly understood the order of the division bench. And that is the reason they filed the appeal.
With section 5.
With section 5. They have understood that in the section 5 application is to be paid.
Yes.
And since the appeal is to be, they calculate the time period also. They are trying to justify the delay period. Now the delay period, what they have considerable in the petition, there are two paragraphs the learned tribunal could not follow, accept is the correct, follow
Show me those two paragraphs. Show me those two paragraphs.
paragraphs were nine, the learned tribunal has recorded the 9 and 10 possibly paragraph.
Yes, where is that 9 and 10?
Geologically come to page, my lord, this application at page 74.
Mr. Ghosh or Mr. Mojumdar, can you ask any of your juniors to bring that tribunal rules?
I'm trying to get actually.
I think some taxation rules also.
Yes, yes, yes.
Taxation rules, municipal building tribunal taxation rules, I think.
I'm trying to get my lord.
Yes, Mr. Ghosh.
Geologically come to page my lord 74 starts. Geologically come to page my lord the 76.
Yes.
Paragraph 7, it is to mention herein that the deed petition served by the learner upon record of the deed petitioner, Mr. Vishwarup Acharya, was incomplete and it contains only the copy of the deed petition without any annexation. The learned advocate and record of the petitioner, Mr. Chandrajit Chatterjee, immediately after receiving such communication have served a letter to the learned advocate record, the private respondent requesting to provide a supportive document and annexures to the deed petition dated 5th March 2024, and after receiving the same, the learned advocate record of the private respondent had served the entire set of deed petition along with annexures 6th March 2024.
So 6th of March, they were served. So according to you, they had knowledge, or according to them also, they had knowledge of this order on 6th of March 2024.
About the order.
About the order.
Although so far as the proceeding is concerned, they had the knowledge, but they did not pursue, take any information. What is the outcome of that proceeding? They kept silent.
Who were the persons responsible, Mr. Ghosh? Who were the persons responsible? Were all the names of the persons responsible indicated anywhere in the proceedings?
Yes. And others, includes my all brothers.
And others, Mr. Ghosh, is a very vague thing. Is a very vague thing. Because when you initiate, because these are demolition proceedings, person responsible.
He never say that I had no knowledge about the proceeding.
No.
I have not got the
First,
notice.
Mr. Ghosh, first is when you initiate a demolition proceeding, it has to be against person responsible as per the statute. No dispute on that. So you have to identify the person responsible. Merely by saying one name and others is a very vague thing. Who are the others? Who are the persons responsible? Now, because the statute says once you initiate these proceedings, you have to notify the persons responsible. So when you say Mr. A and others, so others becomes very important, because whether all were served with that notice or not, that's the very basic question for the initiation of the proceedings. So unless you indicate, that is why I'm saying maybe in some case where everywhere you need not mention all the names, but do you have any document to show who have you identified as persons responsible and against whom you have initiated the proceedings for demolition?
It has been also held by our court, my lord. This issue, my lord, cropped up regarding person responsible. My lord, when our person, my lord, goes to any premises and find, my lord, some wrongs have been committed, then, my lord, nobody.
I could not follow.
Some wrong has been committed in the matter of construction works.
Yes.
Nobody all the time gives the name who is the actual behind the screen.
Yes.
Then, my lord, when I go to the spot, whoever the person is found doing the work, I used to give notice on them. Because it is his premises, the person knows that here the work is going on. Therefore, it has been held because it might not be possible. Then it will be an issue by the all person that I have not been given a notice. He has been given a notice to the Minister of National.
So according to you, only service of notice upon any one of the person responsible
yes, because
is a sufficient compliance.
Yes, it is because it is in respect of particular premises. What is happening? Therefore, somebody has been notified. Therefore, otherwise, my lord, this only that interpretation in that way. That is not the interpretation I'm submitting about the division bench because I have the occasion to meet that issue. Because it can't be possible. Then the person concerned all the time will about the notice and will not the measures will not disclose the name of the actual person. How I can get the proceeding? I can initiate the proceeding at all. Therefore, a proceeding is initiated in respect to a particular premises where the unauthorized works are going on. Therefore, whoever person is
Is
found,
any system as per the rules or anywhere, do you follow that pasting the notice on the?
yes, sometimes we do that.
Not in all times.
No, not only if somebody does not take it, somebody takes it, some years again, some Munna Shah is taking the notice. He will not accept the notice on the spot I have given to him.
Then there is no necessity of.
Difficulty. If nobody wants to take it, then we paste it and take a photograph of that.
All right. So those may be on merits. So so paragraph 9, you are placing paragraph 9 at page 77.
My lord, just clarifying what fell from my lord, that they have not received from KMC regarding this proceeding. If my lord refers to my lord's earlier order in the earlier civil revision, they received a notice on 28th April 2022 for the purpose of hearing, which was fixed on 23rd May 2022. My lord, this was abundantly made clear that this was in respect of this SOB proceeding. So they were in knowledge of the proceeding from 28th April 2022, my lord.
All right. Yes. Yes, Mr. Ghosh.
But therefore, it appears from the order of the learned tribunal that they had the knowledge at the time of proceeding. Maybe, my lord, they have not pursued the matter for one reason or other. That we could be. I mean, they, my lord, ultimately also have seen that they filed a petition, formal regulation, all these things have been done. Therefore, they had the knowledge. It's not that they absolutely they might have no knowledge, my lord, only from that day. Even, my lord, the 6th of March, 6th of March 2024, when they got the complete deed petition, they had the knowledge about that.
Yes.
Then upon receiving the entire records from the deed petition, mode category annexure P4, the petitioner came to know for the first time that an order under section 400, 401 and 416 has been passed by the special officer building with a direction to demolish the wall shown in the red color at parking spaces. Then the order has been annexed P4.
Yes.
Immediately after having the knowledge of the said order, the petitioner have taken instruction from the learned advocate for the petitioner without making any further delay have approached both the learned tribunal to ventilate the grievance of the petitioner and by pointing out the irregularities with respect to the order dated 5th December. That is the disbelief, the learned tribunal disbelieved this paragraph. And what more, immediately thereafter, the 6th of March 2024, they immediately got to the tribunal. The tribunal has not accepted this paragraph specifically in its findings.
Yes.
The petitioner was never served any notice of the respondent authorities or by any special. This is also wrong statement because Your Lordship has recorded in the earlier proceeding that he had the knowledge of the notice. Or by the special officer building department under section 400 subsection 8 with respect to the any hearing dated 4th November 2022, the order of which was passed on 5th December 2022 with respect to demolition case 59 such and such. The petitioner has been entirely kept in dark regarding the case, D case number such and such, and not even got the scope of defense themselves on represent himself before the hearing on 4th November 2022. The petitioner submitted that the deep-rooted nexus and conspiracy occurred between the such and such. These are the things. This is the only the explanation in the petition for delay, condition of delay of so many days. The tribunal, my lord, sometimes, my lord, section 5, of course, my lord, may not be there. The person who wants to get an appeal for hearing. My lord, when a matter pertaining to unauthorized construction, another issue, it is to be looked into from different angles. The diligence of the party, of course, my lord, the procedure has been laid down. Therefore, one may move. But I cannot even permitting him to go before the tribunal. I can say that because it is a small issue. Unauthorized construction change, if it is seen, whether permissible or not. It could be even at the High Court, good my lord, one hearing it could be ended. Here in this case, my lord, the unauthorized my lord, the change of sanction use, the car parking space, number one says. The car parking space has been changed to a commercial place. Now, car parking space is a mandatory. But the number, depending on the number of floors.
Depending on there is a ratio with regard to.
Ratio, but therefore, my lord, it is to be maintained. Whether it is sold or not sold, it is to be kept vacant. Then this is the issue that tribunal has, my lord, allowed one, my lord, change of use. The first floor change of use has been allowed, especially with a building. And only it says that so far as the car parking space is concerned, the partition wall to be removed. This is the order of the learned tribunal, especially with a building.
Show me once that order of the SOB.
SOB, currently come to at page number 72.
Yes, which portion you are trying to? Page 72, this gives those report of the borough.
No, I'm sorry, Malan, sorry. 85.
Infringements have been indicated. So infringement is on the
8586. 8586.
page 72 is the order.
70 order of the special is
8586.
Page number 8586 is the
no, 70 order. Yes, it is.
Same order.
same order.
This is because of Mr. Mujumdar. He has annexed same orders to 3 places.
Basically, come to my lord.
That is not my doing, man. Blame Mr. Mukherjee and Mr. Chatterjee, not my blame. It's a part of the annexation there.
So, Mr. Ghosh, there are 3 infringements. One infringement is with regard to rear open space. Second is with regard to car parking. Third is with third and fourth is unknown. So actually infringement with regard to 2. One is with regard to car parking. Though sanction was 14, as per the building rules was 18, but you now cannot say 18 because you have sanctioned for 14. Since you have sanctioned for 14, now the violation is at the site is 9. At the site is 9.
Get the entire building demolished. That will serve the end of justice.
Blocked. Well, the entire
And
egress to the building has been blocked.
Violation is with regard
The
to
building is without completion certificate.
rear open space. That is one.
Yes.
Second is Mr. Ghosh. Why have you allowed occupation of a premises without completion certificate?
I have not allowed.
Yes.
What steps have you taken, Mr. Ghosh?
Somebody,
Mr. Ghosh, it's within your knowledge that this property is being occupied. And with regard to this, on the face of this order, no completion certificate could have been issued. And Mr. Mujumdar says, on facts, completion certificate has not been issued.
yes, my lord.
So if completion certificate has not been issued, what the statute requires upon you? What's your obligation? Have you performed that?
But completion certificate.
Demolition is one part.
But completion
Occupation
certificate-
without completion certificate is the other part.
If the completion certificate is not granted, 2 months partial completion certificate is granted or full completion certificate is granted. If the completion certificate is not at all granted, it is incumbent upon the person who is making the construction not to occupy the premises.
If occupied,
But if occupied, my lord, then
please take steps with regard to that. Please take steps.
it may, my lord,
Why are you keeping quiet? Nothing prevents you from taking steps with regard to that. What is the section of completion certificate?
theoretically appreciate one thing, my lord, that nobody, when the parties are, my lord, at logger between themselves, my lord,
I am not on any party. I am on your statutory obligation. Have you?
power, sometimes it is activated on the complaint or receiving sometimes. Sometimes it is not, but within knowledge, the passage is already completed or not, or they have approached to us for completion certificate.
No, Mr. Ghosh, on the face of this order of SOB, no completion certificate could have been granted.
No, of course, my lord, if
On the face of this,
the violation is, my lord, before completion certificate is one
it has not yet been set aside.
No, my lord, the violation, my lord, violation, my lord, before completion certificate is one aspect. Sometimes it happens that after obtaining the completion certificate, violation is there.
Mr. Ghosh, rear open space cannot be after completion. Rear open space violation infringement is.
I don't give the completion certificate at all.
That is why I'm saying,
I don't give the
what is
completion certificate at all.
what is that section with regard to completion certificate?
400.
Just 1 minute.
এটা আমার না।
400 something there. 96.
তাহলে পসিবলি এটা সেখানে কেন 415%?
403. 403.
sanction
বসো না mixed up নাম লিখে তার মধ্যে 20টা তোর করা।
And if it is occupied without the completion certificate, what are your powers, Mr. Ghosh?
My lord, so far as that is concerned, let me see, my lord.
403 subsection 2. 403(2) subsection 2.
No, this says no person shall be permitted to
Yes, ma'am.
occupy or use.
Yeah,
That's the bar upon the persons.
right.
What is their power if it's anything it's violated?
Jilasi kindly come to.
না এখানে ওই নিচেরটা ট্যাক্স নিচ্ছে।
সব পড়ি।
In fact, my lord, corporation is collecting
come
taxes
to-
from me for this portion.
363, page 363,
Page?
363 schedule penalty.
Oh,
My lord, corporation is collecting tax for space C, ground floor.
sir, Mujumdar collection of tax is
It's
a
a
different
different
thing
issue.
altogether.
That
Those are the old views.
Right.
Once you collect tax, you cannot demolish another. So
has been taken care of by
now the present statute, schedule,
Change of user, the change of user is
one thing. Mr. Ghosh, schedule, which schedule?
schedule, my lord, 6, my lord, 6.
Yes, schedule 6.
You can see, my lord,
Yes,
that
403 2. Yes,
403.
fine. Fine.
But the violation is 412. What is the consequence of violation?
412.
12. Subsection 1.
No, daily fine which may be imposed 25 rupees.
Yes, vacated. No, this is dangerous.
No. 403
Who
also.
fails to vacate,
Or in contravention of 396 or 403.
403 is for completion certificate.
Kindly
yes,
take note.
yes, Mr. Ghosh, why are you not exercising your power under 412?
412, my lord, then I'll exercise. Now I come to know all these things.
Wow, Mr. Ghosh, what are you saying? From where you are coming to? Your order is
Everything is there.
you as
You have spent the proceeding the last 2-3 years.
পুরো বিল্ডিংটা উড়িয়ে দিই ঝামেলা।
Things continuing. The court is passing an order. Court did not look into the law. Nobody will assist your lordship. And now all these things are over. If your lordship says a power exercise, I can exercise.
please
But you
exercise.
cannot forget the proceedings were one after the another comes to the court. Our court is passing an order overlooking everything without being assisted by the law.
Yes, because Mr. Ghosh, one thing, I'm asking you to exercise these powers now because for one reason. Let us for the moment assume that the order of SOB stands. Let us for the moment assume that Mr. Mujumdar's civil division application is dismissed today. If that is so, SOB's order stands.
Of
If
course.
SOB's order stands, then you have to take further steps with regard to SOB's order. So prior to that, taking steps, vacating the premises is the most important thing. So you start doing from now because there is, you can take instructions. I can keep it on another day that whether you have issued because that's only on the basis of submission of Mr. Mujumdar. And my prima facie observation is that in view of this, you could not have. But you have to
I
take
could,
instructions.
it can't be said, I could not. If somebody applies for partial occupation, the portion which is authorized, I can permit.
So
That
is
power
why-
is with me. It's not that the full completion, that is submitting full completion to one thing,
that is
partial
why-
completion is another thing.
that is why I can
But maybe the authorized portion, I cannot say that I will not allow you to occupy. But he can say the violation of 403, of course, because he could say that somebody has not applied. This is one way to think that somebody has not applied, therefore I have no occasion to consider.
All right, I will fix
Now
that.
the court post facto the permission could be granted. But there is no difficulty in that. But my landlord cannot be enjoyed with a plea that so far as
Ghosh,
this
if you
concept
say-
right will be remained.
You say that post facto permission with regard to violation of Rule 62, then everything can be regularized.
Violation of
Rule 62, as in the SOP's order,
my lord.
rare open space, it is from the plinth level itself. It's violation. If you say that can be regularized, then this order has to go.
No,
That is why.
my lord, regularization, I tell you that regularization, when I consider I am the primary authority.
Yes.
My authority, my lord, may commit wrong. I am not saying that 100% my lord right order is passed. That is the reason the upper forum is there. Then it will come to the tribunal, then before this high court. Then we have the observations, my lord, in many cases, how the court is dealing with that issue. Therefore, I could be, my lord, happy if the highest court of the state, my lord, that they passes an order keeping in view of the statutory provisions in force. But that is sometimes lacking. Therefore, my lord, if I committed wrong,
Lacking, Mr. Ghosh, you are the authority.
if I,
You are implement the
if I
provisions.
committed wrong, then somebody is coming to the court is looking, my lord, matter in a different angle. Otherwise, today, because of this the judicial system, I tell you, lordship, the total unorthodox construction, we talk, my lord, big in the social platform, the unorthodox construction is going on. But how we are dealing with such unorthodox construction? But if that certain vices are with us, well, I want to be corrected by the judicial forum. But had it been looked into that way angle, in piecemeal manner, somebody court, somebody house dashed to from fifth floor, I have the option. The court is monitoring. The fifth story building has been dashed to the ground. But so far as other, the court is saying, look into the matter, do this, that. But therefore, your lordship, set aside all this thinking. But it will not end. Therefore, I am submitting to your lordship, my lord, so far as this case is concerned, my lord, he had went before the tribunal, my lord, after the order of the division bench. Division bench, my lord, has not said that the limitation period to be waived. Because it can be said tomorrow, formally he has to make an application.
According to you, Mr. Ghosh, your sum and substance of your submission is that only division bench permitted them to file
an appeal. The certificate copy and that is to be treated as regular.
With the copy that was annexed to the writ petition.
Yes.
Writ petition.
That infirmity were there to regular.
Anything more?
But therefore, the reasonings we have been advanced, but that has not been acceptable, unacceptable, correctly. Because his reasoning is not proper. He did not correct the disbelief by the tribunal. Hence, the tribunal has rejected for so many years.
All right. Anything more? Yes. Yes, what is your submission?
May I take?
Mr. Ghosh, can you get that taxation rules? Mr. Mujumdar, your juniors are having those gadgets. None of you can find those rules.
I am looking up, my lord. That is what I am trying to do. But it is not available in the KMC website. It is not available in the UDMA website because there are the two websites. There was one.
Those rules are there.
My lord, I am sending. I am sending right now.
Yes.
The old book. That's a 2010 book, I think. 2010 or
might be also earlier. There in the back side, you will be having those taxation.
Justice Oboni Mohan Sinha's book on KMC.
Yes.
That had all the rules. Your lordship may recollect. Justice Oboni Mohan.
Because I have considered that rules in one of the matters and I have delivered
in the website. These rules are not there.
Yes. What do you have to submit? Yes.
Section 4. My very limited point.
Mr. Das, can you shift to your right because we have to use the mic. Yes.
My lord, section 403 provides for filing of an appeal against any order of the KMC. My lord, I'll just read out: any person aggrieved by an order by the municipal commissioner made under subsection 1 may within 30 days from the date of the order prefer an appeal against the order to the municipal building tribunal appointed under section 415. My lord, it says firstly date of the order. My lord, now admittedly, even if we don't take the notice that was received for participating in the proceedings that was drawn up, which has been referred in my lord's earlier order dated 28th April 2022, my lord, it can fairly be well established that they were in knowledge of the proceedings, and finally of knowledge of the order when the writ petition was served along with the order, they chose not to appear in the writ.
So according to you, if a person is aware of a proceeding, then from the date of the order, irrespective of the fact that whether certified copy has been supplied or not, the limitation will run from the date of the order. That's the proposition you are.
My lord,
Yes.
my lord, this is already been concluded. My lord, I'll get this judgment, very recent judgment of Justice Chandrachud, who has pegged the issue that if you have participated in the proceeding, if you have received a notice of the proceedings, irrespective of the fact whether you were present at the time of passing of the final order or not, or if you have received a copy of the order from the date of knowledge of the order itself, you are aware of the order and hence the statutory period of 30 days.
Show me the judge.
My lord, offhand, my lord, keeps in the second half. I have this judgment which I have referred to during the course of submissions before the building tribunal as well.
But it has not been referred to.
My lord,
Show me whether it has been referred to.
referred to.
Can you give the reference? Mr. Mujumdar is having those gadgets.
Yes, I can find out.
Can you give the reference?
নাম্বারটা বলো বা নামটা বলো ভাই। ইমপিউন্ড অর্ডারে তো লেখা থাকবে তাহলে।
Impugned order, yes, 2010 is no. 2010 volume has 8 SSC.
My lord, this
So
is
that's
2010.
that is the only decision which was referred, has been considered here.
2010, my lord, Justice Chandrachud was perhaps not.
Well,
No, there is another 2014 decision which has been also quoted in or referred to in page 4 top of the impugned order. AIR 2014 Supreme Court 746. Yes, that is the private respondents, they have referred to this. Please check this.
AIR 20.
2014 SC 746, page 4 of the impugned order. First
I'm
paragraph.
getting it right now. I will get it right now.
Because they referred to this judgment.
Yes, I will get it right now. No difficulty. AIR কত রে?
Yes.
AIR 2014. Supreme Court. 2014 SC
746.
Justice Bobde's judgment. Kindly. This is
Justice Chandrachud was also a party to that.
Justice Chauhan and Justice Bobde.
No, please show it to him whether he's relying on that proposition or not.
Judgment is relying on. This was cited by Manali.
11, 12 and 15.
This judgment, please show me the which paragraph.
11, 12 and 15.
Now, may I just hand up the judgment to you?
So please show it to him because he wants
To be taken out, please. Sorry.
Which paragraph you are relying upon? 11, 12 and 15.
কত রে? Paragraph
11, 12 and 15 they have referred to there.
11, 12, 15. That has been quoted in the order.
Yes, but it has been quoted.
But when I've got the judgment, I can hand it up to you. Definitely.
But specifically, what has fallen from my lord is that whether the knowledge of the proceeding or even
These are the paragraphs which are relying upon.
my lord, this is a 2013 judgment.
These are 14 judges.
14 judges.
2014 judgment. My lord, offhand, my lord, keep saying the second half, my lord, anytime, 5 minutes, my lord. Sir.
But only one thing, my lord, before, because my lord, my learned friend will have to address it in a better way. Kindly take page 88 of the petition. This is the second order passed by the Honorable Division Bench.
Second order.
My lord, after this first order permitting, kindly take when the appeal was disposed of, what were the observations by the Honorable Single Judge?
That was the, at that point of time, it was.
That
kept
was not the
pending.
final order. No, that was not the final order.
Yes, page 88.
Now, order passed, kindly take from page 89. Order passed by special officer building of so and so is appealable. Appellant before us preferred an appeal belatedly. Be that as it may, since the appellant before us preferred an appeal against the order passed by the special officer
So
building.
which page?
I'm sorry, 89. 88 it starts.
You said 88.
I'm sorry, my bad. I'm so sorry.
Yeah, order passed by the, yes,
The-
applicable. Yes, I've got that.
Because prior to that, only submissions are recorded.
Yes.
And KMC was represented. Order passed by the special officer building KMC exercising jurisdiction under 400 subsection 1 of KMC Act is appellable. Appellant before us preferred an appeal belatedly. Be that as it may, since the appellant before us preferred an appeal against the order passed by the special officer building KMC dated December 5, 2022, it would be appropriate to permit such appellant to pursue such appeal before the appellate authority, albeit authority, in accordance with law. Court is informed that the private respondent before us applied in the pending appeal before the building tribunal for addition of party therein. Also, as noted above, there is also an application for grant of stay filed at the behest of the appellant before the building tribunal. In order to balance the equities between the parties, it would be appropriate to direct the KMC not to implement the order of special officer building KMC dated December 5, 2022 till January 31, 2025 or until further orders, whichever is earlier, passed by the building tribunal on such issue. Building tribunal will consider, we have to consider the application for grant of stay and also any application including application for addition of party without being prejudiced by any of the observations made by us in this proceeding, including the grant of limited order of stay. After that, my lord, the section 5 is being rejected. I put the question to myself. And my lord, judgments are cited and judgments are referred as if, my lord, something is and the authoritative text is being laid down. Is this the practice? Well, this is clear in defiance of the order passed by the Honorable Division Bench.
Then move on appropriate application.
No, my lord, I am before your lordship. And the approval of this MIC was granted in the
November
16th November 2024 after filing of the appeal. 16th November 2024, the approval of MIC was given.
And as per their regulation,
Where is that record?
It is with the case records. Kindly ask the KMC to produce the case record.
So where did you find this?
I have already in my RTI indicated that there was no approval.
Yes.
As on
So,
29th.
where from you are saying that there must be some document? Where is that?
না তুমি দেখেছো নিজের রেকর্ডটা are you sure you are making this?
But Mr. Majumdar, there is no statement on it.
Statement আছে কোনো? কোথায় আছে বলো my revision application no show me the averment দূরদূরি করো না যেখানে প্লিডিং করা আছে yes kindly take paragraph 31 specific pleading on oath. And that is why, my lord, the certified copy was given to us on 26th November. That is 10 days later.
Which paragraph you have said?
Para 31 of the petition.
After the order was approved on ATO, the purported
on November 16, 2024.
Right to appeal the cruise. No, certified copy, where have you said? When it
certified copy, my lord, we have this.
Oh, received, paragraph 33. On November 26, 2024.
That is 10 days later.
And you have filed the appeal on? Please give me some dates.
We have filed on 11th November 2024. I preferred appeal pursuant to the leave granted by the Honorable Division.
Appeal filed.
Without certified copy.
Yes.
And from here you say that November 16, 2024
is the approval given by the MIC to the order, final order.
I got the certified copy
on 26/11/2024, I got the certified copy from the department. While the appeal was pending. Then,
Yes.
my lord, rest follows.
All right, yes. Yes,
My lord, even if it is so, leave has been granted to apply without a certified copy. They filed the appeal. My lord, thereafter, the court had directed you consider the grant of stay. I am providing interim protection till 31st, till the stay application can be considered. My lord, if there is delay, they have filed a section 5 along with the appeal. My lord, till the time section 5 is not decided, they cannot hear the stay application, my lord. That is what, my lord, it took around 7 months for that section 5 to be decided.
your application for addition of party has been allowed.
My lord, at the first instance, my lord. At the first instance, we have preferred the
How
application.
could it be allowed?
Before section 5,
An non-existent appeal.
there is no appeal on board.
A non-existent appeal, how could your application
because
for
the
addition of party be allowed?
But
Sir, one thing that's elementary. If an appeal has been filed beyond the period of limitation, there is no existence of any appeal in the eye of law. So an appeal is non-existent. So how can any order for addition of party be passed on such appeal?
my lord,
So I'm setting aside that also. I'm setting aside that. I'm setting aside that in exercise of powers under 227.
my lord,
This ought to have been set aside.
my lord, but the leave was also granted for our application to be considered.
How?
My
Could
lord,
not have been granted. Sir, could not have been granted. So your granted, but you have been added. Your application has been allowed. Could not have been done unless delay is condoned. It implies delay has been condoned. Yes, anything more? Yes, Mr. Das. Please give me. And Mr. Das, what is this law with regard to this approval of the SOB's order is necessary by the
That is referred to. There is a circular referred to in at page, my lord, 57, 58. And we have got the circular, my lord.
circular. Please give me that
Yes,
circular.
ma'am. The circular was issued, my lord, when, my lord, Board of Administrators were there in KMC. And that is being followed as per their own RTI reply.
No, where is that with regard to the certified copy?
That I do not know, my lord. But it is a matter of practice that they don't.
No, this is the taxation rules. I was right. So it says that with regard to this filing.
In that Justice Sinha's book.
The taxation rules, and that should be in the building.
No, it says.
Tribunal, that is the separate rules are there.
No,
It is conduct of business
assessment tribunal rules.
It is alada has.
Oh, this is the corporation. No, there is any appeal.
I was just looking up. But if your lordship kindly take section 189, section 189 of the KMC Act. I was just looking up why this question popped up. My lord, kindly take section 189. Unlike
that is with regard to the valuation.
Assessment tribunal, which says along with a copy of the order.
Here it is not that along with the copy of the certified copy of the
And
order.
they don't accept. It's a matter of fact. I am making this statement.
You are right, because the matter which I had dealt with was with regard to revision of assessment.
Yes, madam.
With regard to that matter, I have considered.
I do not know whether building tribunal rules exist or not. I do not know. I'm not.
There has to be some
Must
rules.
have. But madam, we have
Has
seen
to be-
many acts.
Building tribunal rules are there.
No, সেটা কোথায়?
Building tribunal rule এই বই আমি মানে
It does. It is there.
Sinha's book.
I can search it better.
And is it
Please
Justice
search
Sinha's
it.
book? That is the. There was another book by Common Law House which contained also.
Kamal Kumar.
This is the
Please search it out whether it is Dinto.
Well, I cannot resist the temptation of citing this judgment. This is our High Court. Kindly take the paragraph, my lord, which I have just handed up. The exceptions where order is not to be may not be communicated.
Which portion you are relying upon?
1, 2, 3, 4. There's a at CDA team.
Yes.
Copy এনেছি যার এই judgment-এর? My lord has got that part. I'm sorry, my lord. I should have.
1, 2, 3.
Oh, there are these are the exceptions where order need not be communicated.
If an order is made which affects the rights of a person, then the order must be communicated to such person in order to be complete and effective. The date of the order is the date when it is made known to the.
Made known.
This is also my prima facie observations, because unless.
My lordship will find from the exceptions.
And while I was there, I argued one of the matters in, I think, Bengal excise or so, and you accepted that you were on the other side.
Yes.
Because there also the limitation from the date of the.
I was not a bad other side.
From the date of the order. So I argued that it was not communicated because I was.
The lordship may remember there is no scope for condoning delay.
There was no scope for condoning. And that was a case where I all along participated. So even the last date, order was passed in my presence. I argued that even if an order is delivered, unless I get the copy, I cannot draft the memorandum of appeal.
But kindly take this one. Eta ache to. This is 59 to. Etai porchi to.
Yes, yes. Those are those exceptions. Order is made in the. When the order is made in the presence of the party.
Justice Deepnarayan Sinha's judgment.
Yes, yes. Where the order has been made to the party affected to be present at the announcement. So, if it is made in the presence of the party,
it is done.
Then exception.
Exception. Then, my lord, kindly take. II. It is very relevant.
II, yes.
Where the notice has been given to the party affected by the order to be present at the time at the announcement.
So, if on the date of hearing notice is given, that today will be the date of passing the order, you please remain present.
That has not been done here. Admittedly, hearing concluded in November, no notice was given.
Mr. Mujumdar, have you checked up? This has not been said.
No, this has been followed.
It has been followed.
Yes, this is the law. Absolutely, my lord.
Sir, what do you say to this judgment?
Today, my junior actually submitted before. Today, my difficulty is this. I was on the impression matter will be taken up Monday, and I am not.
Monday.
The order. I actually here in.
No, I said you do not
uploaded till now. Today I got it. Today, rather, my lord.
No. But after signing, after uploading, yesterday it was uploaded. It was.
She made it.
Yes. Don't say that. Because prior to leaving my chambers, I've seen that it has been uploaded. Mr. Das, don't say that it was not uploaded. Because I left, I tell you, just before 8. Prior to that, it was uploaded. Don't say that.
I am actually dependent upon my. That is.
You have been not correctly informed. Don't say that. There is an indication. Apart from that, I have checked up.
Actually, heard wrongly. Here.
No. Mr.
Monday, the matter.
I have said don't take steps till Monday.
And the matter to return its position in the list.
I have said that. And that is the order which has.
Today I am handicapped.
These are my respectful submissions.
Today you are handicapped with regard to what?
Regarding my melody.
Let us make submissions.
Mr.
Ghosh has made his submission.
These are my respectful submissions, but this order should go.
Yes. Where is Mr. Ghosh?
Mr. Ghosh is just one in division.
So only one thing, Mr. Mujumdar, because Mr. Ghosh has to give reply to this judgment.
Well, then kindly stay.
Stay is there.
That can be extended for 3-5 days and
well, kindly make
then after
vacation reopening. After vacation.
If Mr. Ghosh can come at 1:15, all right, 1:10.
Very well, my lord. Very well.
Mr. Mujumdar, please make yourself convenient.
Yes. Well, I will be here, or Mr. Mukherjee, we will try to be here. We will try to be here.
Yes.
At 150.
Please. Only I know for the arguments you have made,
My lord, I'll just place
you
the
can
judgment.
also reply to this judgment.
Great.
And if you can search that judgment, what you are saying,
Now I'm getting.
please, Ben, if you search that judgment, please give a reference in advance to Mr. Mojumdar or his advocate on record, so that Mr. Mojumdar, if that decision is being served, please.
একটা judgment এর copy.
Yes. Yes, call the next matter.
Item number 11.
Soft copy নিয়ে নাও। তোমার phone number টা দাও।
Lordship, I'm for the petitioner, Lordship. Lordship, this is that matter where the wife is the petitioner before your Lordship in a divorce proceeding by mutual
Your
consent.
other side.
No one is appearing, Lordship. Dear Lordship, what happened? The wife is staying at the USA, Lordship. So we made an application that evidence can be given, Lordship, through virtual media. That was turned down, Lordship. On the last occasion, I have handed over a bunch of orders, Lordship, passed by the district judiciary itself, Lordship, where similar orders were passed.
Have you inquired whether in that courtroom infrastructure is there or not? Even if I allow your prayer,
Now, on the last occasion, your Lordship said that in all the courts, the infrastructure is there. But your Lordship is
that is
thinking
in
about that more.
Chakravarti, that is in place because everywhere it's there. Where it's functional or not, have you taken instruction? Even if I pass an order, that will be an infractious order.
Lordship, they are saying that yes, Lordship, virtue. It is going on, Lordship.
Through commission.
Through commission, it is going on.
It is now in place. Everything has been made ready. I have assured that. So, this application under doing?
She's a student, Lordship. Kindly
Write
read.
it there.
Yes, yes.
ওখানে একটা paragraph করে দেবেন।
It is mentioned of the application for mutual consent.
Where? The next year.
Yes, Lordship, at page 19, Lordship, it says that she's a student, but the address is not given there. But this was affirmed through Lordship, the consent.
এখানে এই অ্যাড্রেসটা দিচ্ছেন না, সেটা ওনার সাবমিশনে ওটা রেকর্ড। ঠিক আছে? হি ইজ দ্য স্টুডেন্ট, ওটা বোধহয় বলেছি, শি ইজ দ্য
my client has issued the Vokalatnama in a plain paper, not in a bond paper. So I'm praying, undertaking that during the course of the business course of the time of the court, I will submit the Vokalatnama on behalf of the respondent number 1.
Your lordship may recall, my lord, this is that matter where, my lord, the petitioner has sought for recalling of the witness, and unfortunately, my lord, there was a 10 July 2025, my lord, I am appealing that order passed by the learned additional district judge, first court, Kollani. My lord, what has happened, my lord, the learned advocate was conducting the case, but there was some miscommunication and could not appear, and as a consequence thereof, my lord, the petition has been rejected, and that's why, my lord, the date has been fixed for, and the evidence has been closed. That's why, my lord, I have come up before your lordship. But I am only beseeching your lordship, kindly fix any date, and so that, my lord, the witness can be recalled, my lord. This is that matter, my lord, where the, according to me, my lord, the will has been, my lord, executed under a suspicious circumstances, because my contention all along,
part of the trial, lordship.
My contention is that the testator, my lord, lost the mental capacity to execute the will. When he executed the will, my lord, he doesn't have the mental capacity. So that's why, my lord, that is the will I have challenged, my lord, on that count. And, my lord, the beneficiary, and also, my lord, she has been, my lord, examining the mother, the fight between mother and son.
Where is your adjournment petition?
Yes, lordship. My adjournment petition. Your lordship has gone through the order, my lord. The order impugned, my lord.
Yes, please show me the adjournment petition.
My lord, actually what happened, my lord, when I reached the courtroom, I came to know that the learned advocate will not appear. Then, my lord, out of, my lord, haste, my lord, I personally appeared, and I said that because the non-presence of the learned advocate, well, I sought for accommodation. That was the sum and substance of the case. And the learned judge said, because this was going on.
Yes, what do you say?
May I, lordship, the on order number 43, subject to the correction, learned trial court was pleased to fix the matter as DW, and since then the petitioner herein did not file any DW. After a long back, the petitioner filed a recall petition on 3rd August 2024. So after that, allowing the petition, again the petition is dragging the matter.
Okay, what is the next date fixed?
On last
defendant's witness have not been examined.
They have
now, right now, my lord, the plaintiff, my lord, the executor, my lord, possibly, my lord, he's
all PW completed.
PW completed.
No, PW was closed.
Yes,
PW was closed.
I have to
6th of September 2025 was fixed for defendant's witness.
Yes.
What happened on 6th of September?
Because there was already your lordship has passed an order of stay, so that has been communicated to the court bureau. Till 18, my lord, there is a stay, impending stay.
All right.
So,
and next date in the month of December.
Next, on that date, ask the PW1 to be present on that date.
That my client is 80 years old, and presently
on that date, that will be completed only on what?
Only on that day, sir. But
or otherwise through video conferencing.
It's difficult. One day because you appeared.
She is present. Lordship, kindly. She is presently residing with her daughter at Kolkata, and she is not present residing at her Kolani residence. That's why my client has not received the formal the summon copy. I have been communicated through over phone that today is the matter, so I appear on behalf of that. And during the
if it is video conferencing, you can make that prayer before the learned trial. Yes, then you will be at liberty
because being as 80 years old of a client,
there is difficulty because some persons, their representatives will also.
I understand. Kindly direct that
date evidence. I'm not saying any more.
No more adjournment.
Yes, no more adjournment, and
Cost, my lord. So far the DW.
Cost.
My cost has already been awarded. I will pay that.
No. That is for the earlier day.
My lord,
For
the
this.
2,000 rupees,
Yes.
my lord is quite a hefty, my lord.
Maybe you are trying to drag.
No, I am not begging, my lord. My lord,
This
there
is-
was only for 2 days, my lord.
No.
There was.
80-year-old lady, she has to be compensated. Otherwise,
So, fight between mother and son, my lord.
Maybe.
My lord, kindly consider this as it
yes,
will.
you are the son.
I am the
Yes.
son.
Why
I
are
have
you
not
fighting?
received any.
Don't fight with your mother.
My lord, their only difficulty
Mr.
is
Kali, after all, you will be paying to your mother, not to an outsider.
I will pay,
Please,
my lord.
being a son,
My lord, right.
being a son,
I will
how
pay.
much you volunteered to pay to the mother? Please tell.
Then, my lord,
Being an officer of the court, you are not paying to an outsider, you are paying to your mother. So, considering that relationship,
it's a
please
very
quote the figure.
typical, my lord.
Yes, that is why please quote the figure, considering the relationship of
A mother and son relationship, my lord, cannot be owed by, my lord, monetary consideration.
that is why. That is why it is cannot be
Cannot be
calculated
my
and
lord. If the
that is why.
relationship is like
You
that.
will be paying to your mother, how much you will pay?
Sorry,
After all, you are
it's very
UP.
difficult, my lord. It's a question, my lord, for me. But considering, my lord, the present condition of the petitioner, my lord, he is presently, my lord, is not employed. That's why, my lord, I am making.
Maybe.
My
But
lord,
mother, you have to
5,000, my lord.
5,000 is
No.
nothing.
My lord, only
You
for a
will
day.
We will be paying to your mother. You will be paying to your mother. Mother, Mr. Kali, not on one day. On that day, she was here.
So
She was there. You did not.
Kolani, my lord.
But
He
she is
decided to
presently
Presently,
at her
he is
court.
staying with the daughter.
Just
But the
one-
whole difficulty, the daughter
She came on that day. She had to return. She has to again come on another day.
Permanent resident is Kolani, my lord.
Maybe she had to come to the court. She had to come to the court on one day. She had to return again. She had to go to the court. Maybe from Kolkata or Kolani, whatever it might be.
It's the
So
hard
5,000.
2,000 was there. Already court has awarded, my lord.
That
I am bargaining, my lord. I am saying 5,000.
High Court, it does not look good 5,000.
Kindly consider the present condition of the, my lord. Received that.
You will be paying to your mother, not to an outsider.
I'm paying. I am
That is-
taking care of also, my lord.
Yes.
Presently.
Take care, take care. Yes. This application under Article 220.
Extend it, but I know 1 minute time, Lord, kindly gives me 1 minute. I will not take more than 1 minute. But
All right.
only 1 minute. Yes, yes. Lord. The landlady, Lord, in a suit for eviction, initially filed declaration in the form of mandatory injunction, the recovery of possession. Since recovery of possession in an explicit language not prayed for, twice, Lord, I lost in both the courts. Second appeal preferred. The second appellate court ultimately my appeal allowed, directed me to correct only their plea with regard to adverse possession negated. My plea with regard to that incorporation of prayer of recovery of possession amendment was directed to be done within a certain time. COVID came in. I filed the application. The court said it's a belated application. The COVID benefit has not been given to me. My client is really is doing the household works in other places, and this place is being used by a club in respect of a property where they are charging for 1 day. For 1 day, 1.5 lakh.
1 minute over.
And he is
1 minute over.
that is the
What do you want? What do you want?
if your lordship fixes any day, any day, she is doing household works to others in respect of his own property where the club is utilizing 1.5 lakh per day. And my difficulty is that, I must be candid before your lordship, the club authorities came to me saying that I want to purchase it from your client at the present market rate. My client said it's my father's property, I will not sell them. But she is doing household works to other places. She can't even spend anything.
Acha, Ashun. Was on 7th of February 2024.
And 7th January, this has been admitted by the order. Yes, yes.
Mukherjee, while on the earlier occasion it was extended.
Direction was there by the coordinate bench of your lordship's court that I should serve. Since there at that juncture there was no caveat, I served. At the time of extension, I handed over the affidavit of service. Now, in the interagnum, I find after moving of the revisional application, one caveat is being lost.
So on the earlier occasion, 15th of May, when I had passed extended this order, then also prior to that caveat was lodged.
But post caveat, your lordship knows our notice has to be given to my advocate on record.
But now you are saying it's in the website, it's in the records also.
Nowadays, it's appeared in the website. So I shall serve and come back before your lordship.
Mr. I give you prior notice for this. Order has to be recalled.
I cannot justify my lord that my lord obtaining of that.
Yes. Who is appearing? Yes.
This is my lord. The plaintiff before your lordship, my lord. So legal aid, my lord. The interim order is to expire by the end of this month. Your lordship extended on the last occasion.
Have you served upon the other side?
Yes, my lord. We served all of.
Many times it has been
It has been, my lord. I have got the earlier order. Earlier twice we served.
The interim order is still
End of September.
End of September. Well, kindly fix after vacation any day. We can even intimate them so that this lady, my lord, can get rid of this.
none appears. No, Mr. Mukherjee. Weeks. Yes, next.
12
After 12 weeks.
18, my lord, I am for the petitioner.
You are for the opposite party, yes.
parties.
Yes.
It's a application for amendment of my injunction application, which was rejected on the day of filing of the application.
Rightly rejected.
My lord.
Yes.
Lordship, my instructions are to place, would it please your lordship to place this matter any day post vacation, lordship?
Yes. After hearing the learned advocates for the respective.
Item number 16.
16.
Paper given actor.
I appear for the opposite party in this matter.
Who is appearing for the petitioner?
I had filed a caveat. I have not been served also.
None appears for the petitioner. Please start.
Been engaged by the advocate on record.
Advocate on record, engage your senior. Yes, no problem. Please start. Please start.
I don't know anything about the matter, my lord. I am seeking for accommodation.
Why?
Well, it has been instructed by the advocate on record.
Where is the advocate on record? Ask him to come.
He cannot come to court.
Yes.
For 10 days. He cannot come to court for 10 days.
The learned advocate appearing for.
No, 17 mala the plaintiff is the petitioner before my lords mala.
Yes.
Early disposal for the partition suit filed in the year 2021. Mala the defendant mala injunction.
21.
Yes.
Partition suit cannot be disposed of expeditiously.
Mala the WS filed by the defendant number 3 who obtained mala the order in the year 2023 for mala the making construction. He filed the WS in the February of this year. Now, the last date was fixed on 3rd September for filing the WS on by other defendants.
Service is ready.
Yes. Now, the next date is fixed on the 20th February 2026 for issue.
For framing also registered statement filed.
I collected the website.
This application under Article 220.
In.
Yes.
18, my lord, I am the deputy
Dismissed.
petitioner. Before your lordship, suit for declaration.
Not appearing.
Lordship, permit me, I can appear.
Then it will be dismissed. Yes.
Suit for declaration, my lord. Suit was filed 2000
for?
declaration.
Yes.
Suit was filed, my lord, 2019. Written statement accepted was accepted, my lord, 6 February 2000.
Number 1 Rule 10 application is pending.
Yes,
23rd
my
of
lord.
September.
Yes, my lord.
Written
My lord,
objection
two
filed.
application.
Written objection filed.
No, my lord.
Not filed.
Two application filed.
Two applications. What is the other
pending.
application?
Order under order 39, rule 1 and 2.
Rule 1 and 2, that is also pending.
Yes, my lord. And my lord, ad interim refused on 11th.
Ad interim?
Refused, my lord.
Ad interim refused.
Yes, my lord.
Copy served.
No, my lord.
Then how they will appear? This application under Article 2.
Lordship, the judgment we have
Debater.
Lordship, the judgment debtor is the petitioner before your lordship. By the order impugned, lordship, the occupational charges has been increased to lordship from 8,000 rupees to 54,500 rupees, lordship, and also
From 8,000 to 54,000.
and also lordship 2 lakh rupees.
When I was there, from 8,000 to 1,20,000.
But lordship kindly considers, lordship, this was a decree for specific performance of a contract in respect of 100 square feet of a shop room, lordship. Now what happened, lordship? They levied execution. Now it was passed. Initially we appeared in the suit, but thereafter did not contest. So lordship, after the ex parte decree was passed, my order 9 rule 13 is pending. Now, lordship, first lordship occupational charges was awarded 8,000 rupees. Thereafter, they filed a modification application stating.
They filed.
Yes, the decree holders.
So you are happy with 8,000?
Yes. So, lordship, they filed a modification application saying that we have let out the that shop room in violation of an injunction order passed by the executing court, and we are getting 35,000 rupees out of that, and so They prayed for 40,000 rupees. That was their prayer, Lordship. Now, Lordship, we did not produce the copy of that agreement. And on the last occasion, the learned executing court, Lordship, passed 35,000 rupees. Challenging that order, we came up before your Lordship. Your Lordship again sent back the matter. And in the meantime, we produced that agreement and directed the learned executing court to decide on the basis of that agreement, Lordship. Now, Lordship, by the order impugned, Lordship will kindly see how, Lordship, the order impugned was passed.
Mr. Bhattacharya, the miscellaneous case under Order 9 Rule 13 has to be disposed of expeditiously.
Two things. Probably my learned friend has missed two things.
Missed two things.
Yes, yes. There was
You point out those two things.
Yeah. This was a commercial property.
Shop room, I've said.
Commercial property. They have created a third party violating the order of injunction.
I've said.
Yes, submitted.
They are obtaining 57,400 as of rent.
Yes.
Renting the property.
57, she said 35,000?
No.
First, Lordship, 35,000 they said, but by the order impugned now 50.
Came up before your Lordship. Your Lordship directed them to produce
Yes.
the lease deed.
Yes.
Upon production of the lease deed, this was the thing. But kindly see the
Lease deed, the rent is 57,300.
The 500 square feet, Lordship.
No, there cannot be 500 square feet because the sanction plan produced by them before the court below, which says there is a 100 square feet shop room. Kindly see the
Lordship, kindly sees the deed, Lordship.
Cannot go because this was the sanction plan produced by them before the court below. There are 3 shop rooms. One is 9 point some meter, equivalent to 106. There is a 10 point, which is much better, and it's 3 point something. So, if my lord kindly sees
Which shop room is the subject matter? Can you put a pencil mark on that?
The decree.
Can you put a pencil mark on that?
Because this was the sanction plan obtained by them.
Which side you will take?
By our leader.
No.
Kindly looks into the order. Kindly looks into the order. Nothing more I shall submit.
Take your seat.
Will the junior division writing this sort of an order? Your lordship wouldn't have imagined. Kindly look into the order once.
It's a wonderful order. Kindly see that mark.
Please take your seat. You are running from another court. Please take.
I am literally.
But this was the sanction plan which was produced by them in the court below.
Sanction plan.
No, so
Because there cannot be 500 square feet shop room there as per the planning.
where is the lease deed?
Kindly
Is it being annexed?
Page
92, Lordship, 92.
92.
92.
Whatever they can see in the lease deed.
No, they are saying this is a deed.
Lease deed says how, what is the square feet?
500 square feet.
Yes, 99. Page 99 is the schedule, Lordship.
That says 500, but kindly see the sanction plan. Sanction plan, there is no provision of 500 square feet in that building, shop room. How can they say this thing?
Page 99.
Yes, Lordship, that is the schedule of the premises.
But here measurement is not there.
Yes, 500 square feet.
Yes, 500. No,
This is from the sanction plan. Sanction plan, there is no 500 square feet shop room.
It cannot be decided here, Lordship.
Oh,
So
this
the
was
executive
the
said
sanction
no.
plan of the building.
Then let them take steps.
Revision court.
now where is the plaint?
Yes, Lordship, the plaint is at page 27. The schedule is at page 32.
27.
Go and satisfy my property, my portion, I will go away.
27.
27, the plaint starts and the schedule is at page 32. 100 square feet, Lordship.
Now,
Decree was also in respect of 100 square feet.
all right.
Sanction plan.
Decree was also
Decree, square feet.
Decree is at page.
One thing. This suit, this schedule
Yes.
is which portion of from the sanction plan, Ms. Chakraborty, please show me.
Let them show, Lordship.
They have indicated. They have indicated. That is why I'm asking you. They have indicated by putting a pencil mark.
ওরা বলছে এইটা
ওরা বলছে
thing. The learned trial judge also proceeded on the basis that it's 500, not 100.
Yes, yes.
You have also not challenged this. So the learned trial judge, the reasoning of the learned trial judge is 100 square feet is included within 500. So we cannot now enter into this fact. Now the question is, if the shop room, the decretal property is 100, so that's the subject matter. So can the occupation charges be directed to be paid anything in, over and above the decretal property? Because you have also not, it's not that the learned trial judge has proceeded on the basis that their claim is 500, your claim is 100, the court finds that it's 100. No. Court says yes, 500, but that 100 is inclusive of that, or that 500 includes that 100. That's the finding.
But this sanction plan was produced by them.
Mr. Bhattacharya, but this is the learned trial judge did not go into that. Learned trial judge did not record that it is
another thing,
100, not 500.
Another thing, kindly see in 2019 itself, this court, the learned trial judge in the execution proceeding has passed an order of injunction.
Yes.
Restraining them to be making third-party rights.
Yes, yes.
Everything. Violating that order, they have.
Yes, I accept that. For that, I cannot open my mouth any further, because for that they are being saddled with the occupation charges, right? She is not also denying her liability. Now the question is, for that they will be liable to pay occupation charges. There is not dispute with regard to that. Now the quantum, whether they have to be, they will have to pay occupation charges on 100 or 500. That's the only
500 in, as per the sanction plan.
Mr. Bhattacharya, that's the finding. That's the finding. That's the reasoning. You have not challenged this order. You have not challenged this order.
Not, but there is no 500.
That's the order. Mr. Bhattacharya, I can only go into the reasoning and the materials. List deed says 500. Mr. Bhattacharya, there are two documents. List deed says 500. Plain says 100. Court also proceeded on the basis that the shop room which they have let out or transferred, whatever it might be, is 500, not 100.
So the conduct also, my lord.
Yes, it's conduct, everything. For that occupation charges.
And as per the agreement, the court.
As per the agreement is 500. So if as per the agreement of 500 is 57,300, that's the rent. Proportionate it has to be.
Yes.
And in terms of your lordship's order, I have already paid 80,000.
Lord, so desires kindly record that from now onwards, anybody violating the order of injunction can do anything. Only there is
Mr. Bhattacharya, Mr. Bhattacharya, it's not a question of doing anything. It's a question of.
But they are enjoying. It's a fight between brother and sister.
No, no.
Brother is depriving the sister in this manner.
Mr. Bhattacharya, you are entitled to 100, not 500.
I am entitled to 100.
Yes. So, even if assuming that they have let out or transferred 500, 400 in excess, 400 we are not concerned. So we are concerned only with regard to 100. With regard to 100, the
cost.
Kindly do not cost. It was the 2019. There was specific order of injunction. Why they have got in the lordship?
Kindly look into it.
Is the cost.
Anybody violating the order of injunction.
So what then have to release this matter? Do you mean to say raising your voice will improve your case?
See the conduct once.
Do you mean to say raising your voice will improve your
Kindly
case?
looks into the order made by the learned court below. And he looks into
no, cost. What is the cost?
2 lakhs.
2 lakhs.
Why 2 lakhs? Where is the finding with
last paragraph?
Please see page 101. I'm sorry, with the impugned order.
Last page?
No, second last page.
Second last page.
Last
Judgment debtor also intentionally took an untoward stance even on repeated approach of this court for production of such these documents earlier.
So, Mr. Bhattacharya, conduct is not good. Your conduct is no, maybe, but because you have not produced repeated occasions, you did not produce.
With respect, I mean,
Mr. Bhattacharya, if you had produced before the learned trial judge on the first occasion, these proceedings would not have happened. Would not have happened. It's only
We have produced the document.
After the, I directed,
Yes.
not before that. It was your duty to produce that. So
See your lordship.
conduct is not good.
Please,
I can consider the quantum of cost, but cost has to be imposed.
please see your lordship's order. Kindly see
Cost
your
has to be
lordship's order.
imposed.
I may be incorrect, Milord. Please see your lordship's order, page 87, 86.
Yes, yes,
Milord, kindly see page 87.
yes.
The petitioner filed an application. I'm reading from page 87. Praying for stay of all further proceedings in the title execution case, alleging the petitioner herein have inducted a lessee in a portion of the decretal property and is earning a substantial rental income. Therefore, the opposite party herein filed an application praying for direction upon the petitioner to pay occupation charges as a condition for stay of the execution. By an order dated this, the learned executing court passed an order of stay of the execution subject to payment of occupation charges at rate rupees 8,000. Thereafter, the opposite party herein filed an application under this for modification, alleging that the judgment debtor petitioner herein is collecting rent at the rate of this per month. The learned executing court, by an order dated July 20, 2024, directed the petitioner to file affidavit along with the agreement. Subsequently, the learned executing court, by an order dated November 16, directed the petitioner to pay rupees 35,000 directly to the bank account of the decree holder. Mr. Chakraborty, learned advocate, appearing for the petition.
So, Mr. Bhattacharya, pausing here for a moment. So, executing court by an order dated July 20, 2024, directed you to file the affidavit along with the agreement.
Yes,
Did you file that?
Recalling application.
I will come to the next paragraph. I'm asking you, did you file that agreement at that point of time? No.
At the point of
We filed a
Yes.
recalling application.
Then, yes, then,
Mrs. Chakraborty, page 88.
yes,
Appearing for the petitioner submit an amount of rupees this was fixed on the basis of submission of the learned advocate.
that is, yes.
This is another thing. A copy of the lease deed has been produced by Mrs. Chakraborty before this court. Mr. Bhattacharya submits that no copy of such lease deed has been supplied to the opposite party hearing. The learned advocate on record for the petitioner is directed to supply a copy of the lease deed to the learned advocate.
Mr. Bhattacharya, I faintly recollect that incident.
Okay.
On that date, upon insistence, Ms. Chakraborty produced.
Yes.
And we handed over the
After
copy of
that,
it.
so it was not annexed also with the civil revision application.
Because recalling application was there.
The recalling application was.
No, with the revision application that. So you did not produce before the executing court. You also did not produce in the revision application. When in course of hearing, I directed her, then she had produced.
Then kindly will not see your lordship's direction.
Yes.
Page 88. I may be incorrect, Milord.
Yes.
After going page 88.
Yes.
After going through, Milord, the materials on record and after considering the submission made by the learned advocate of the parties, this court is of the considered view, the occupational charges has to be fixed by taking into consideration the agreement entered into by the petitioner with the third party and other relevant factor. Since the agreement was not placed before the learned executing court at the time when the impute order was passed, this court is of the considered view the impute order is required to be set aside. Accordingly, the order is set aside and the application under section 151 is restored to the file. The learned executing court is directed to reconsider the application filed by the opposite party, praying for modification of the order dated this. It has been submitted by Mr. Bhattacharya, learned advocate for the petitioner. The petitioner herein has not paid occupation charges, etc. He submits that till the end of July, occupation is left over. The petitioner herein is directed to pay 80,000 to the bank account of the opposite party. We have paid that.
That is, yes.
That
was the amount which was directed to be.
Directed to furnish the bank account. It is however made clear the amount directed to be paid.
Yes, what you are trying to show.
What I am trying to show is, this direction of my lord, at page 88 bottom, has been given effect to, in a wrong way. In a wrong way. Why wrong way?
By imposing cost.
No. Kindly look at the consideration at page 101. Please see 101.
Yes. 101 is the certified copy.
Oh, sorry. The order dated, the order impugned.
Yes, 13th of
August 2020.
Yes, which page? Which page?
Second page.
Yes. Yes.
Now, please see. Now, at the factual onset, from that, this court finds that the plaintiff has obtained an ex parte decree in respect of decretal property measuring 100 square feet. It remains an admitted fact that the judgment data appeared in the connection with the original suit. It has also turned apparent from the same, the judgment debtor did not take part in the suit proceedings. It further goes that the judgment debtor being party and being aware of the agreement between judgment debtor and him, decree holder and him, leased out 500 square feet of space in favor of one popular pharmaceutical chain. Needless to mention that the learned advocate for the judgment debtor, number one, admitted the fact of an agreement between the judgment debtor and the decree holder, did not prefer any suit or case for cancelling of such agreement. It is next impliedly admitted that the alteration of the configuration of the suit premises has taken shape without the leave of the decree holder. Judgment debtor number one did not leave any free space measuring about 100 square feet as per the admitted entitlement of the sister. So this typical activity clearly signifies his intention to wipe off and or eliminate the subject matter of the original suit itself. Thus, judgment debtor removed the head for the headache. Though it sounds funny but uncanny for the cunning judgment debtor, number one. Thus, judgment debtor remains a childish delight with his crooked understanding of law. This is not civil. Kindly pardons me, Lord. I was telling my learned friend, this sort of a language, this is not perhaps civil junior division, writing this sort of a language in an order. Perhaps your lordship, in your lordship's wide experience, has not seen such type of a.
No, I do not have wide
experience. With greatest of respect, even before the Honorable Supreme Court of India or by your lordships, in any order, this sort of a stand, as if he is the decree holder. He has stepped into the shoes of the decree holder and he has taken up.
That is the duty of the executing court, Mr.
With respect, this is not the reasoning. Then, kindly see, judgment even did not produce the lease deed that he entered with Med Plus. The judgment debtor did produce the lease deed before your lordship's court, and on that reasoning, the matter was remitted back to the honorable, to the learned court below. So, that reasoning, and therefore, the conclusion is, so, first of all, the occupational charges, the entirety, whatever is being extracted from Med Plus, 57,500 for the entirety, and, also intentionally took an untoward stand even on repeated approach of this court. With respect, that portion of the order, the repeated approach part, merges with your lordship's page 86, 88 order. It merges. Why it merges, subject to, I may be wrong, why it merges, because the moment your lordship has taken up the matter, and your lordship has directed exchange of the agreement and has further directed the learned court below on setting aside the earlier order to consider it on the basis of the agreement, this portion of the reasoning is incorrect, subject to correction. Otherwise, the proximity of courts, the courts, hierarchy of courts do not function. So kindly, today your lordship passes an order. One line, the honorable Apex Court, or the Supreme Court of India, there is no margin. The moment, and previous order is set aside and the matter is remanded on the basis of an agreement, as recorded in page 88 bottom, I respectfully say, it was not open to reopen the issue. It was not open to the court below to reopen that aspect of the matter. Since, your lordship, directed us to give the copy to my learned friend. We handed over the copy. That is the instruction. We handed over the copy in court. So the agreement was there. It is not any attempt to shield any particular document. Agreement is not something so expensive, so valuable. Kindly visualize, a cost of 2 lakhs on this sort of a matter. What have I done?
You are on the quantum or the impose.
I am on the endeavor to impose cost. Forget about the
anything
No,
more, Mr.
yes,
Vajra?
Yes, please.
J order 78, page 78.
Please see the part of the order.
Page 8.
Please see, the court herein has been directed.
No. 8. Page 78.
I'm sorry.
78, yes.
The judgment debtor 3. No, 20th July, whereby I was directed to produce that deed.
Please see, page 78.
Yes.
Judgment debtor filed 3 petitions, 1 petition under 151 for recalling the order dated 20th July 24, wherein this court directed judgment debtor to furnish affidavit showing actual quantum of license fee, rent for occupying the suit property by one pharmaceutical chain, namely Med Plus. Judgment taker took time on the last two occasions.
Yes, what you are trying to show?
হ্যাঁ, তারপরে next
Now,
page
PC 78
this application was rejected.
Yes. Now, that application filed by the judgment getter stood rejected.
Now
Which application?
these
Application for recalling.
Yes, so
At page-
recalling by virtue of which you are directed to furnish affidavit
yes,
showing actual quanta.
Shot was rejected
yes.
by the learned court bill.
তারপর আমরা হাইকোর্টে এলাম
Then we
High Court
came to
set
your
aside that
lordship's
order.
court, and that order
set
made
aside.
by the learned court below was set aside by your lordship's court ultimately. Please see page 79 onwards.
And directed us to give them the
Yes.
copy. So that portion cannot be
So,
edited
my lord,
again.
this portion, page 81,
Yes.
my lord, after page 78 capital A, read with page 81 bottom. My lord, this portion of the reasoning passed by the learned court below, my lord, according to me, is, my lord, an exercise beyond his purview, its jurisdiction.
Yes, Mr. Bhattacharyya.
Harassment. Twice, 5 times the learned court directed them to produce the lease deed. What restrained them from producing the lease deed?
Why?
It was
On
past 20
15.
euros.
I took a very urgent leave. My lord, I rushed to this court, my lord, I was there in court number 16. And Mrs. Chocolate, she is more competent than me, my lord.
It was the multiple times the executing court directed them to produce the lease deed. They did not. Took all deviating steps to avoid this. Pursuant to your lordship's direction, they produced the lease deed in the court. For the years I am harassing, I am not aware what was the exact amount. Pursuant to your lordship's direction, we came to know the actual amount. So kindly seize the order of injunction. They are very well aware that there is order of injunction.
All right.
Violating the order of injunction, they
This
have done it.
application under Article 2
me, my lord, so that I can, my lord,
No, no,
prepare
that may be causing prejudice to either of the parties. That's the difficulty because
She knows, she has understood what was passing through your lordship's
that
mind.
gene is
She
now
knows, my
still
lord.
there.
Yes,
So,
yes, 100%.
so when it was there, it,
Sir, that gene should always be there, my lord.
no, I must know where to stop
No.
and when to stop.
My lord, the civil junior division should know what language to use.
Yes,
Yes.
yes, yes.
Oh, Mr. Mujumdar, I kept him waiting. I'm so sorry.
Yes, Mr. Ghosh, Mr. Mujumdar cited one decision. If you want to make any submissions on that, only for that I have kept. And another one clarification, Mr. Ghosh, Mr. Mujumdar has shown one circular or something saying
Circular.
circular.
It is indicated in the RTI reply.
In the RTI reply, which says that the order of a special officer building requires an approval by the mayor in council. Mayor in council.
Yes, MIC.
By the mayor in council. Is it so?
Question is, my lord, that issue, my lord, has been urged, my lord, in another proceeding. I'm telling your lordship. The regulation says, my lord, that in case of allowing retention, or when the consideration of calculation of fees, when calculation of fees is there, when allowing retention, when the question of calculation of fee comes, my lord, then the matter should go before the mayor in council. Because the mayor in council may accept that order, may not accept the order.
Not in other cases.
Not in other cases.
But only one thing, then
Then another issue I'm telling you, lordship.
So, no, in this case, whether it required approval of the mayor in council, whether in the facts of this case.
The question is, if the order is already delivered and communicated, then my lord, the further.
No, only for that. Mr. Mujumdar, please show me that reply to the RTI.
Yes, my lord. Kindly take the reply to the RTI for once. Page 58.
58.
No, not page 58 is not the reply to the RTI.
Yes, my lord. Page 57. 57. Sorry.
Mr. Ghosh, please kindly come to page 57. Or page 56 first.
Yes.
No, not page 56. Where is the query?
54, 57.
54 first. Please kindly come to page 54.
The RTI application is not annexed.
Yes, annexed. 54.
Sir, it's this question which has to be answered by the corporation, not you. Yes, Mr. Ghosh, have you got page 54? Have you seen question number 3, III?
If any conclusive or any final order has been passed, kindly provide me with the certified copy of the.
Not turn over 57. This is your reply.
57.
III, serial number III, page 57.
As per available office record, the final of the above mentioned premises is at present awaiting approval of the mayor in council.
As per the such circular, the final order can be made public after duly approved by the mayor in council. Now, with that, so this is your reply. So according to you, it was awaiting the approval of the mayor in council. Now, apropos this, please kindly come to his specific statement in paragraph 30.
31. 30 and 31.
Please kindly come to page 31. Sorry, paragraph 31, page 12. This is his statement on oath that this approval, which was awaiting, was granted only on November 16, 2024.
Page, my lord?
12, paragraph 31. Of the writ petition.
Yes, sir.
Paragraph 31. After the order dated December 5 was approved by the Mayor and Council on November 16, 2024, the purported order become, that's their interpretation, it became enforceable.
But that is our submission.
Their specific stand is that it was approved on November 16, 2024, and prior to that they have filed an appeal. And next is 33. They said, because please take in mind the reply you have said, after it approval, certified copy. Their specific statement is paragraph 33. Certified copy was supplied on November 26, 2024. So if this is taken,
On facts, Your Lordship might be said, but I have, my lord, the suspicion on that issue. Because the question is, my lord, whether the order has been made public or not. The issue is, my lord, always, my lord, it is, my lord, of course, my lord, it is required to be approved. Ideologically sees the order of the special officer building first.
yes.
But I can assist you, Your Lordship, because details of the facts, my lord, I cannot appraise Your Lordship, my lord.
No, not on the facts. On this, because this is a procedure. Only for that.
That's right, my lord. That information has been given on the particular premises question. I take it prima facie that whatever communicated under RTI Act, there is the facts on record.
Yes.
I am accepting that. But I cannot say right now, my lord, whether actually, my lord, this is happening on record or not, but I take it for the payment. But the question is, my lord, always the course is taken when the order becomes made public.
So that
even if it is not approved by the Mayoral Council, because Mayoral Council, Liberal says that it's an order to be challenged.
Can you give me that circular, Mr.
I'm submitting, but that's a regulation, not circular.
Regulation.
That is regulation. But I tell you that argument is advanced, that sometimes it is argued. And Malati, it is said that when the order has been passed by the special officer building, because law says the special officer building has to pass an order. It did not say subject to approval by them, but the regulation speaks so. That is the reasons when the question of detention is allowed. Only in that case it is forwarded. Therefore, unless the detention is allowed, calculation of fees question comes, normally it does not go. But if it goes, and if it is the communication, but the law says that if the order is published, then it becomes automatically has come into effect.
All right.
That is the judgment of our court and also the division bench. That a question may come came in a case that somebody said that order has been communicated to me. Not communicated, but he has somewhere collected the order and initiated proceeding before this court. I said, where from he has got the order? Because I have not made it public, I have not delivered it. If the order goes out of my hand, any order, if it goes out of my hand, because it is the order of the special dealing which is to be appealed from. Therefore, if the order goes out of my hand, then it automatically says to have been delivered or public. And you also can see the order of the special building at page 72.
No, that I've seen. No, I wanted to clarify only one thing because only this fact. Because this I'm seeing for the first time. Because my impression was that once an order is SOB is passed, that's final. When Mr. Mojumdar yesterday,
he is correct. He is correct in saying that. But I am on that issue because ultimately, when the order to be challenged, not only approval order or something like
that, I follow.
There was order to be special officer building, and the special officer building order specifically says that any person aggrieved by the order, he may prefer an appeal.
All right. Yes, what is the decision? This decision you want to cite? Which paragraph?
My lord, kindly come to page number 28, my lord.
Page number?
28 of the
Yes.
page number.
Yes.
My lord, two issues which was dealt by this judgment. When will the clock for calculating limitation period run for proceedings under the IBC, which is also a special statute, this is also a special statute. Is the annexation of a certified copy mandatory for an appeal?
Yes.
NCLAT against the order, my lord, this is an order preferred from the NCLT to the NCLAT on a particular IBC issue, which is the insolvency bankruptcy code, and that was rejected by the NCLT because the delay was not condoned. My lord, now kindly come to the middle portion of the order.
It is not open to the person aggrieved to await for the receipt of a free certified copy. I've said that.
Party is expected to exercise due diligence and apply for a certified copy upon pronouncement of the order is 6 to SL.
Yes.
In consonance with such and such. My lord, the statutory mandate is within 30 days from the date of the order. My lord, it is not open to the person aggrieved by an order under IBC to await receipt of free certified copy and to prevent the limitation from running. Not only that, my lord, a slay of interpretation of procedural rules cannot be used to defeat the substantive object of the legislation. My lord, may kindly take up the next paragraph. Mandate certified copy being annexed to an appeal which continues to bind the litigants to the IBC While it is true that the tribunals and even this court may choose to exempt the parties from compliance with this procedural requirement in the interest of justice, the suggests that discretionary waiver does not act as an automatic exception where litigants make no efforts to pursue a timely resolution of their grievance. My lord, if it was such that this order was awaiting the approval of mayor and council, why was it not indicated in this order itself? It says any person agreed by this order, which is
All right.
question. May
I've seen
appeal
that.
this order.
Well, a quick reply, paragraph 4 of the judgment.
Paragraph 4.
ও মিলছে না দেখা তো kindly take paragraph 4 of the judgment.
Yes. The NCLT is impugned on the 13th of July.
No, my lord, I'm just coming, paragraph submission এর আগে দেখো না
Before the submission.
This is reported and I think it's reported before the submission দেখো হ্যাঁ এই যে paragraph 3 in your lordship's copy it is paragraph 3.
Yes.
May I just place paragraph 3?
Yes.
On 31/12/2019, NCLT held that performance guarantees were not part of security interest as defined in so and so. The appellant has not disputed his presence before NCLT when this
that exception.
Well,
ঠিক আছে
just one second. My lord, the last paragraph. The appellant was present before the NCLT on such and such date when interim relief was denied and miscellaneous application was dismissed. Participation in the proceeding, my lord, in my lord's earlier order also it was recorded. They had received the notice 28 April 2022 for participation in the proceeding.
Mr. Chalo.
This is the facts, ultimately will the order to be passed on. Based on all facts.
No,
Attend to the facts.
I may miss out something.
Yes,
That is why I am asking.
my junior will be
Because
In a particular case,
it's not possible to go through all the papers and then dictate.
no.
I will have to dictate what is
Yes.
in my memory. So something.
Somebody absolutely will be.
an application of the judgment on all.
And my lord, Mr. Ghosh's presence is very necessary at 2 p.m.
Then you have to be present.
No,
Ghosh will be present if you are
Mr.
present.
Ghosh will be present. I take the lordship's time. Oh, lordship is rising. Sorry.
for a leave to move a CO, my lord,
Yes.
getting my lord permission of that puja, my lord. But I have filed, my lord, the filing department has placed it on 18th.
No, what is the date you have mentioned?
My lord, on Monday, my lord said that it will appear on Monday. So Monday date, my lord, I have to give in, my lord. They are saying we will not accept 15. Yeah.
So you have filed or you have,
Yeah, I have already filed, my lord.
when have you filed?
My lord, yesterday.
Yesterday you have filed. They can, you know,
CO number.
give the CO number.
My lord, one humble indulgence, my lord. Yesterday, my lord, item number 2, my lord, directed to file reaffirm the affidavit of undertaking, my lord. Only thing is, my lord, I have the commission. I have went to the commissioner. Commissioner has given this his signature beside where the correction was made. My lord, the steno was asking me that whether the reaffirmation stamp is required or not, but I have re-verified, my lord. There is no reaffirmation stamp.
You have filed it.
Yes, I filed.
কেউ হাত রেখে কি করবেন সবশেষ হয়ে
Number 20. My lord, item number 20, I am led by Mr. Manoj Kumar Das, my lord. He has left court, my lord, due to illness. I am praying for not sitting.
An accommodation has been paid for by the learned advocate.
One, my lord, I appear for the petitioner. Application for expeditious disposal of a matrimonial suit. I appear for the husband defendant. My lord, 24th March 2023 suit was filed. Thereafter, my lord, it's been pending for a while. After issues framed, my lord, application filed for amendment of the plain, that was allowed. We filed our additional written statement. The only difficulty, my lord, I would be praying for, my lord, to expedite the suit. But, my lord, one more prayer, my lord, if some time frame could be fixed, because, my lord, my client resides outside. He resides in Gurgaon, and he's also an employee of the Haryana Electricity Board, and that's been recorded also in one of the orders passed by the learned court.
Miscellaneous case is for alimony pending.
Alimony, that is also still pending. That is still
Section
pending.
24 of the
Section
case.
24, section 24.
This application under Article 227 of the Constitution.
Dependent respondent petitioner, my lord.
Yes, yes.
The opposite, the plaintiff, appellant, opposite party filed a suit for declaration that the dependent.
What is the impugned order?
Impugned order allowing the, my lord, order 6 rule 17.
The prima facie appears to this court that the application for amendment Yes.
My lord, appellant in a proceeding under 218 of the West Bengal Municipal Act is the petitioner before your lordship. Lord,
So you have become specialist in municipal matters, Mr.
I-
Mukherjee now.
I-
In demolition matters, resisting demolition.
somehow, my lord, it came in the same day, two matters. My lord, it's not that. Lord, I was enjoying in 218 proceeding before the learned trial judge an order of stay. Ultimately, my 218 proceeding got dismissed, my lord, on merit. Lord, challenging that the present revisional application. Lord, I shall take your lordship, my lord, to the order of demolition that has been passed, my lord. That, my lord, initially that has been passed by the Howrah Municipal Corporation. Thereafter, my lord, the jurisdiction of the Howrah Municipal.
What is the wrong in the impugned order, Mr.
But I will take your lordship to that. My lord, what happened? The subsequent, my lord, amendment of the West Bengal Municipal Act, which happened, my lord, after the order of the, my lord, passed by the, my lord, my lord, if your lordship takes up the order of demolition once.
Who are you?
I am the person responsible.
West Bengal Municipal Act do not define person
No, my
responsible.
lord, after the amendment, it has.
Now it has
Yes.
been made.
Rule 32, my lord, I will take your lordship to the relevant date. Lord, what happened? Rule 32 was promulgated. This was given effect to. My application for regularization was there. After, my lord, this particular, my lord, amendment being taken effect. My lord,
Amendment is retrospective.
my lord, I will take your lordship to that also.
Retrospective.
My lord, the amendment came in, my lord, in the second proviso, which was given effect, my lord, which was added rather from 27 July 2023. So 20
It's prospective.
So, my lord, it's not about, my lord, it is a window. It is a window which was not there. But it is a case where this window has in my
Show me that rule
yes, my lord.
32.
If your lordship takes up page rule 32, second proviso, this has been this has been introduced.
Yes.
Now kindly takes up, my lord, the demolition order is 1st of March 2023 at page 44 of my lord's brief.
Where is the circular pursuant to this notification issued pursuant to this amendment of Rule 32?
My lord, but may I just take one small right?
Initial circular, thereafter amendment, subsequent circular. Please show me that. This minor addition,
yes,
or minor these works that has been defined there.
But, in the West Bengal Municipal, but this, not in my respectful submission, I not there may be
You
a
raise this
case.
point.
No, yes. Why may not I raise this point? I say, but kindly take.
You raise this point before the civil
This
judge.
was pending for consideration. This was pending for consideration. May I kindly see the order?
No, pending consideration before the
municipality.
No, I'm asking you show me from the impugned order that you have raised this point.
Impugned order doesn't reflect that. But I have annexed something which is not that this is a brainchild of mine. Immediately after this amendment was brought in, I filed an application. Kindly takes up my application is
Show me that you have said that you have filed an application for regularization which was pending. Show me that from the impugned order.
But this was annexed, part of the appeal.
Show me, Mr. Mukherjee.
In the impugned order, there is no
Mukherjee, you will not raise that point. So, whoever, can you place a point which you have not raised?
This was on record before.
Maybe, Mr. Mukherjee.
Sir, I know, Milord. Yes, it's not possible for another judge, Milord. Yes. But this thing is available.
Press, Mr. Mukherjee, you have waived that right.
But it is not in so many language may have not been argued.
No, what is so many language?
I cannot improve that. I was not there. It has not been recorded. I must be candid before your lordship. It has not been recorded.
So, but Milord, approach there for review.
if in the interagnum, my lord, I was not been protected, my lord, review, my lord, your lordship, no, it's contested order.
No, maybe. No, if you say that you said this, not recorded, it was there, error apparent. These are the ways.
But according to
scope of review.
my lord, according to me, here is a case which is not a not construction devotes to the plan. That means a additional floor or something like that. They are saying in deviation of the sanctioned building plan.
Mr. Mukherjee, all deviations.
No, my lord, I am not on
that circulars.
My lord, I am coming.
Has been
That's why, my lord, I
specified.
one of the matter before the coordinate bench, my lord, in jurisdiction, that if
I have
you say-
delivered an order
my lord,
consistent with circular.
just consider, my lord, my submission for once.
Mr. Probal Mukherjee.
Very
we are
well, my lord, I
getting
will
that.
consult that. Not just 1 minute, not kindly hear my submission. Say, for example, if the regulation suggests up to 30% is a permissible limit, which can be said to be minor. So mine case is maybe 50%, but up to 30 they can retain. They will direct, no, rest 20, you are out of our limitation, so that should be demolished. According to me, here this exercise has not been done.
Which municipality?
It's municipal Bali. It's
Where
Bali.
is Mr. Arun Banerjee?
But I can give you.
Come, bring him.
Very well.
Bring him. Yes. Call him, call him.
Yes, brother.
Let's pass over next.
Item number 24.
For the opposite party.
My lord, I am appearing in the position Mr. My lord, Mr. Honorable Petition, my lord, he could come to the
Why? You are here.
I don't know.
Yes, yes.
I agree with Madam because Madam, challenging the same order for title appeal was filed by date that has already been admitted by the landed court.
Yes, how do you support this order?
But I don't have the copy.
Please take the microphone.
I don't have the copy of the petition. I have not been served yet. But challenging the same order, but after, so far as this is order under challenge, my lord, 18 February.
Miscellaneous appeal dismissed on the ground of maintainability.
Yes, subsequently they have filed a title appeal that has already been admitted. But this is the order. Challenging the same order.
Title appeal is not maintainable. Saying. Yes, you have filed a title appeal. You have filed a title appeal, you have accepted this order. What remains? How can you challenge this order now?
My lord, Mr. Honorable Petition couldn't come today, my lord. I haven't been briefed to
Ask me to come tomorrow.
Your Lordship, Mr. Bhattacharya is appearing on behalf of the opposite party.
Since I'm not inclined to take up this matter on personal ground, this matter stands.
I'm for the petitioner, my lord. My lord,
Yes.
expeditious hearing, my lord, for mispreemption case. The opposite party may enter appearance on 20th January 2025 for filing written statement, my lord. But on 7th May, my lord, they did not, my lord, file. Written statement took time. The petitioner is, my lord, senior citizen, 68 years old, my lord.
Its application under Article 227 of the Constitution of India.
Item number 27.
Item number 27, my lord. Well, I am for the petitioner in this matter. Well, husband is the petitioner with your lordship. Well, certificate copy, well, leave was granted. Well, I am carrying the certificate copy. Well, if your lordship wants one.
Yes.
Well, these are case well, on section 36 of the Special Marriage Act has been well, disposed of without considering the affidavit of assets of the wife, well, without considering the order of the well, DV passed well, wherein well, the wife's claim has been rejected on the ground that she is maintaining herself, but she could not produce any document. Now, well, lordship will kindly seize, well, I am the teacher, well, I am getting a salary of, well, if your lordship takes page 20, man.
What is your salary?
Well, the salary is in Bilboria High Madrasa School. Well, lordship will
Private tuition, private tuition.
no tuition. Well, I've given the notification also, and that's the assessment that has been made
Will
by
direct an inquiry to be made?
Yes, yes. Well, I'm ready
Under
to
which police station?
Lordship.
Under which police station?
This police station is my lord.
So I will direct an inquiry. Inspector
Well,
in
what
charge
I'm
to make
saying-
an inquiry and to submit an-
Well, I'll take your lordship's 2 minutes.
Let an inquiry be made, Mr. Chattopadhyay, whether you are carrying on private tuition.
Well, I have annexed the notification.
For all your private tuition coaching centers will be closed.
Now, what has
This
happened?
call will pay
To be very candid before lordship, my lord, well, an amount has been given of 35,000 rupees.
Hey, that's
Well,
nothing.
no, I'm my salary is lordship kindly takes
the status of a teacher. It's
lordship will kindly takes page 21. Yeah, then the lordship will decide.
Yes.
Well, my salary is 79,376. Now, well, I'm paying GPF and tax.
Page,
well,
page.
Page 20. P1 and except P1. Lordship will kindly seize, my lord. This after this deduction, well, I am in my hand is 59,000.
Yes, loan.
32,500.
2,500
Yes.
installment you can bear, and you cannot pay to your wife of
At that
35,000.
time, well, what? Well, for father's treatment, my lord.
Chattopadhyay, if you can pay monthly installment of 32,500, you have to pay 35,000.
Well, give me 1 second. Well, Lordship will kindly- 1 second, 1 second. Well, Lordship will kindly seize, my lord. 51,700 is deducted. My cash in hand is 27,676.
Maybe cash in hand, maybe 15,000 because you have taken a loan. You can pay
Father's treatment, my lord, I am paying a personal loan. Personal loan, my lordship knows the interest is very high.
32,500 monthly installment. Pay
Well,
35,000.
what I'm saying, well, I'll not bargain, my lord. But what I'm saying, well, as per my instructions is concerned, well, 15,000 I'll pay, my lord. 15,000 to 20,000 I can pay maximum.
I have not filed any caveat, but
Well, this is my maximum. Otherwise, well, negative balance. Well, running in negative balance. Lordship will kindly seize the loan, my lord. Lordship will kindly seize the loan, my lord. But page 21.
Have my copy.
I'll serve him, there is no problem. Well, he can, well, if my learned friend agrees to that, my lord, in the meantime, my lord, I'll pay him my 20,000, my lord, including my son or daughter, my lord, whoever may be.
Son or daughter?
No, no.
You do not know, Mr. Chattopadhyay, whether you have a son or daughter.
Well, I have a daughter, but my
What kind of a father you are?
Well, I have a daughter, my lord.
No, I'm not asking you.
Well, I have to take.
I may be having a son, I may be having a daughter.
Well, 20,000 I'm paying, well, Lordship can record it, man. 20,000 I'm paying it.
How are you paying 20,000?
Well, I'll pay from here, because 35,000 has been given.
Yes, are you getting 20,000?
No, I'll pay 20,000, man.
You will pay.
Yes,
From when it was directed?
Well, it was directed, Lordship will kindly takes, my lord.
From which date?
Well, it's date
2022.
Yes.
So 20,000 from 2022, which month?
No, not 22, मतलब it was given मतलब from, मतलब according to the white book annual from the date of the appearance of the case payable on 10th day मतलब now I'll give from this month only. And after that the whatever the area matter I'll subject to I'll
Yes, that is from 2022. This case has been filed.
yes. But that
2022,
that is
3 years, 20,000. So
seven.
per-
Well, again a personal law will come into present.
Yes, yes. So pay that amount.
Let me count.
20,000. Pay that amount. I will stay this.
What I'm paying before your lordship, but 20,000 I'm paying. Well, the area amount whichever the calculation will come, I'll sit with my learned friend, and we'll secure. I'll come back within a week.
No. Please pay the entire areas.
Well, entire area I cannot.
20,000 you are agreeing.
20,000 I'll pay.
20,000 with regard to the areas, there cannot be any difficulty. So whether you have to pay 35,000 or 20,000, I will consider.
Well, only I'm paying. Well, area, give me some time. Well, because
Yes,
this loan will.
Time. How much time you want?
Because well, I have the instructions. Well, this loan will continue for another 8 to 1 year. So, well,
2,40,000 for 1 year for 3 years.
3 years. It will come around well, 6 lakhs and 7 lakhs and something.
7,20,000.
20,000.
So
that
pay
is
it in 2 installments, 7,20,000, and I will keep that pending whether it will be 20, 35 or 20.
Well, it's better. Well, I'll come back with that instruction. Lordship will kindly direct me
instructions.
Give me a week's time. Well, give me a week's time. Well, I'll call him. Well, so how can we make the arrangement that has to be? I'll just.
Basic salary is 60,176. His basic salary
is
60,176.
Yes.
He is paying a monthly installment of 32,500.
So that is there. I have produced the records. But that is for the father's treatment. Well, I have also shown the documents also.
So I record your submission that you will pay at the rate of 20,000 per month till the matter is heard out.
Well, 20,000 I am now paying. Yes, but that I have the.
You are paying.
You
will
pay. 20. Yes.
Don't stay in present tense. Stay in
I'll pay. Well, future that area I'll come back.
You are saying I am paying. I thought you are.
Well, what I am trying to show you. If your lordship kindly sees the DV order.
But pay the maybe DV order.
Well, DV order has been. Well, in that case, what has happened? From his cross-examination, it has been come. That she has an earning. She has an earning. Now, in this order, if your lordship sees.
Then I am directing inquiry with regard to your private tuition. Ashun.
Well, lordship will kindly. Well, and in this order, no affidavit has been filed.
Yes,
I
yes,
have
Mr.
instruction
Banerjee.
to appear for the municipality, but so far as I remember, I haven't gone through the brief. In this matter, the writ court directed demolition, my lord. Demolition order was passed. Writ court directed to implement that. Appeal
Mr.
preferred.
Banerjee, why did you allow this construction to come up?
But, possibly, my lord, this construction
But
was
that I have asked you to come. Why did you allow this construction to come up?
it was within the aegis of Howrah Municipal Corporation at that point of time. Sanction was
Initially,
given,
order of demolition
sanction was given. Then Howrah Corporation my lord, took over Bali Municipality. Now after demerger, my lord, this case was filed when we find that already made.
Yes, what do you say?
Division bench directed, my lord, writ court directed demolition, implementation of demolition. Against that, appeal preferred. The order of demolition has been directed to be implemented. No, not interfered with the division bench, but liberty was given. You can prefer an appeal. That appeal was preferred. Now the contempt has been filed. Contempt court has given us time to demolish and come back with police help. This is the position.
So I'm doing one thing. I'm releasing this. Let it be tagged with that. Because there will be conflict of decisions then.
But the cannot conflict of decision. What
One is the implementation, another is challenging.
implementation is always not subject to the appeal.
So the same court can also decide this. We'll be in a better position to decide this. We'll be in a better position to decide this. And once this is decided, execution or can be execution application can be dismissed then and there, Mr. Mukherjee.
Protect me, Milord, for this.
Yes, I'm releasing this to be tagged along with that.
This under Article 227, I cannot, Milord, go there.
Why? Assigned.
Milord, assigned.
Yes, I'm recording that order with regard to that. To be placed before the Honorable Chief Justice.
Milord, these are separate avenues. Her Lordship was, Milord, hearing in respect of a contempt jurisdiction in spite of the fact that since my appeal got dismissed in the meantime on merit. So I am before your Lordship under Article 227, whether that rejection is proper or not, I argued before your Lordship with
Mr.
regard to
Banerjee,
that.
what do you have to submit on merits?
Lord, I haven't seen Lord, the ground of appeal or the petition. Kindly allow me to come back on Monday. Let a copy be. If the matter can be heard on merit on Monday also, I am ready to address the Lordship.
Monday, fixed at 12:30.
12:30. Oh, Monday 12:30.
We as agreed by the as agreed by the learned advocates of the parties.
Good. Number 28.
28 not answer the petition. Defendant is the petitioner. One of the plaintiff file a suit for permanent injunction. I purchase this property. Defendant purchase the property from one of the Kundu Chaudhury's estate. One of the Kundu Chaudhury's properties.
Vimal Krishna Kundu Chaudhury.
Shantimay Kundu Chaudhury. Kantimay. One of the Kantimay Kundu Chaudhury.
Yes. Yes, yes.
Now, my lord, in connection with the repeated that my deed was.
What is the order impugned? Order 6217 allowed.
17 allowed. My lord, what is my
Order
case?
6217 of plaint.
Of plaint. My lord,
Yes,
what is my case? The plaintiff in by filing a GA in the, before this honorable court challenge my deed. They said
Plaintiff by filing a
GA interlocutory application in connection. GA, my lord, in the original application in connection with that suit, Kundu Chaudhury's.
Oh, original side suit.
Original side.
Yes.
My lord, they challenge my deed for cancellation. That Kundu Chaudhury has no, the joint receiver has no power to sell the property. Now, my lord, by virtue of this amendment, he wanted to incorporate these facts. My lord, I am on, my lord, if my lord, these proceedings, my lord, cannot go, my lord, the learned trial court, my lord, directed this fact is required to be incorporated. My lord, in my lord, that suit is in that suit, my lord, I am claiming my title on that deed, and that deed has been challenged by the plaintiff before this honorable court. And they also filed, my lord, one writ petition Since I have started construction, kindly comes to page 33. Order passed by the Honorable single judge directed not to make any further construction. So certainly I am in possession of that property in question.
So Ghosh, have you checked up? I think in that original side matter I appeared.
But I have to check, I am remembering one.
Any application for leave pro interest
that is Justice
application?
Patheria, Justice Patheria. Before Justice Patheria, code number 8.
Application for addition of party, I think I appeared. Since I'm not inclined to
But without allowing her to construction, repairing. No, I file an application for modifying the order.
no, I could not follow.
In a suit for partition, my lord, there is order of status quo. I am the defendant. I file an application, my lord, kindly allow me to erect my construction. I pay not pay for any equity. That application was allowed on 4th of October 2024. My lord, without allowing my application, my lord, granting my lord to repair. I file an application.
Where is the impugned order? What is the date of the impugned?
No, my lord, this is expeditious disposal of my application for modification of the order.
Yes, so.
This is the application, my lord, kindly see the order. My lord, the order sheet. Well, I filed put up petition. Put up petition was fixed on the date fixed. On the date, my lord, the PO is only.
What is the next date fixed?
16th of September, my lord. On that date, my lord, may I kindly allow, my lord, kindly direct him to dispose of the application, my lord. Nothing
Application under Article 227 of the Constitution of India is a
May I get a plain copy or 16th of September, the order was passed.
Item number 30, Mr. Kushal Chatterjee is appearing virtually, my lord.
Yes, Kushal Chatterjee is
He's appearing virtually.
He's
My lord,
appearing.
I am appearing for the
Yes, Mr. Chatterjee. That's Aniruddha Chatterjee.
No, my lord, Kushal Chatterjee, my lord, item number 30.
The nameplate says Aniruddha Chatterjee.
My lord. No,
But he's above Aniruddha Chatterjee.
No, my lord. The name is appearing above.
Yes.
Yes.
No. Lord, what happened, my lord, the petitioner, my lord, challenges, my lord, an order whereby, my lord, his prayer, my lord, for, my lord, having a cross-examination of handwriting expert was rejected.
Or he proceeds.
My lord has heard this matter, kindly recall, my lord, order dated 30th of June 2025.
Party, my lord.
Dead persons. Yes, Mr. Chatterjee. Why have you made dead persons as parties?
My lord, I have copied from the cost.
My lord, 1 and 6.
1 and
1 and 6.
that prior to the filing of the civil division application or after that?
No, prior to that, and substitution has been.
My lord, in that case, my lord, I need. My lord, I need the names. My lord, it is their plain. It is their plain, my lord. I need to have the names, my lord. Their plain, my lord. I need to have
the same, please.
Because there is no.
This order sheet is there. Order sheet of substitution.
When this matter is taken up for hearing, Mr. Shane Lanes, senior advocate appearing for the opposite party, submits that the opposite party numbers 1 and 6 passed away long prior to the filing of the civil division
So far as the
application.
one, my lord, the years are already on record. So far as the six, substitution has to be, addition has to
So
be done.
one, if years are already on
No,
record,
no, six has, six.
only six.
Six.
Kivalam passed away long prior to the filing of the civil division application. Mr. Same further submits that 1 and 6 passed away long prior to the filing of the civil division application. Full stop. Mr. Shane further submits that the heirs of the opposite party number 1 are already on record as opposite party numbers
2 to 5.
2 to 5. Full stop. Faced with such situation, Mr. Chatterjee, learned advocate, appealing for the petitioner, pays for time to take necessary steps in this regard. Yes, after the vacation,
Milord,
Mr.
kindly
Chatterjee.
makes it very well, Milord. Kindly keeps it, Milord, in the same position because my right of cross-examination has been closed. Milord, on the last occasion,
Started under the same heading immediately after reopening of this court after Puja vacation. Mr. Shane, please furnish or give him the copy of the substitution
affidavit of
application.
service we kept on record.
Affidavit of service taken on record. Next.
Number 31.
I pay for the opposite.
Opposite party.
Mr. Oyun Banerjee is appearing. He is summoned by code number 551.
Summoned. What has he done?
Lord, I am not brief in this matter. My lord, I am praying 1 day's accommodation only, my lord.
Take it up on Monday.
You have not been brief.
No.
So then it cannot be. If
Because
your appearance is ensured by the learned advocate on record, then accommodation. Otherwise, no. Where is the learned advocate on record?
Your lordship, advocate on record, your lordship.
Yes. You have not engaged Ms. Damali. And she is coming to pay for adjournment. Yes, Mr. Kaur, what is this matter?
Take it up on Monday, Milord. She will be in difficulty.
No, what is this matter?
This is refusal of ad interim order, Lord, both by the learned trial judge as well as the appellate court.
Ad interim order?
Yes. Plaintiff's, Lord, prayer for ad interim order that has been refused.
Names, I find it's. The suit was filed.
Suit was filed in 25. This was, sorry,
25.
No, a suit was filed on November 24.
Because the name seems to be.
No, November 24.
All right. After the vacation?
No, my lord, probably there is an urgency in the matter, my lord. Kindly make it not today, my
We are
lord.
not in this matter.
But my senior requested me, my lord.
An accommodation has been sought for on.
Now 32.
32 years. Oh, that matter.
That matter, my lord.
Keeping it tomorrow because fixed matters are there. This matter will take some time.
No. I will take only 10 minutes.
Because today you have 3:30 and some matters of 3 p.m. are fixed. Come on Monday, I will
3
take it.
p.m., my lord, I have another matter, my lord.
3 p.m.
3 p.m. another matter.
Call on those 3 p.m. matters. So you will not be prejudiced as a counsel.
But my lord, in the list, my lord, it is found that from the monthly list 3
Yes,
p.m.
monthly list it will be taken up.
But
Monthly
it is not in the monthly list, it is supplemented.
that will because I am taking 1 day's monthly supplementary list was taken up day before yesterday. 3 p.m. matters. Probably
No. Today was the date.
Today
it has been added.
Yes, call the list. Monday it will be taken up.
Yes, my lord. Monday, my lord. Then, my lord, in a state of Monday, these may be fixed on Tuesday, my lord.
Thereafter. It is called on
This matter, my lord. Otherwise, my lord, 30. This is my 32 item.
32.
32, my lord. Your lordship is fixing on Monday.
I'm not saying anything. I'm only passing it over. It will remain in the list.
But my lord, Monday I have personal difficulty. I shall not be.
Juniors to pay for an adjournment.
Yes.
Ask your junior to pay for an adjournment.
I shall keep consent, sir. Lord.
He will be there. Yes. Call Kurun.
Item number 1174.
I'm for the petitioner, Lord.
Yes.
Lord, the petitioner is defendant before the court below, Lord, and
suit for recovery of possession was
What is the
filed, my lord.
impugned order?
Yes, my lord. This is, my lord, after 28 lordship will find, my lord, after 28 lordship, it is
Yes.
certified copy lordship.
Yes, what is the impugned order?
Yes, my lord. My lord, I filed two petitions. One, my lord, for supply of some documents, order 7 rule 14, and my lord, for better information and discoveries, my lord, order 11 rule 1. My both petitions were rejected on the ground, my lord, on the very date, my lord, on 25th March. I prayed for adjournment, for extension of time to file my written statement. That was the ground for rejection of my these two petitions. Lordship may see, my lord, I have annexed the include order that is starts, my lord, after page 28, lordship. May I read, lordship?
Yes, rightly. If you have not filed your written statement, you do not have any right to contest. So why the documents will be supplied to you?
My lord, see the plain lordship. Lordship, see.
Maybe, but you have not filed your written statement, sir, and you have also not prayed for extension of time.
Yeah, I prayed, my lord.
Where is that?
Lordship,
Challenge that order. What happened to that application?
my lord, that was rejected, my lord. Time to file my written statement. Lordship, did it here?
Where is that?
Plain.
Where is your application praying for extension of time? Show me.
Lordship. No, this is, Lord, I have annexed certified copy, lordship.
No, you have not filed any application.
I filed, Lord.
No, you have paid for adjournment.
Lord, Lord, under the circumstances stated above,
Which page?
Your Honor would be, Lord, this is certified copy, lordship.
Certified?
After that order, lordship will find after one page, lordship.
All right.
Please to extend the time for filing.
No grounds have been stated. Mechanically, it cannot be extended.
Beloved,
rightly rejected.
Beloved, my two petitions, might see his plaint was once kindly seen, Beloved.
Maybe when you are served with the summons.
Beloved, sometime in August, Beloved, there was change of
August of which year?
24, lordship. 24, lordship. Beloved, kindly see the plaint, Beloved, once, Beloved, that is, I have annexed my page 13. Very cryptic, Beloved, the order 7 rule 14 says, Beloved,
suit will be dismissed.
All documents will be
suit will be dismissed.
I am prejudiced. I am prejudiced, my lord, to file my written statement. I have prayed for better information, my lord.
By the order impugned, the prayer for
Five. I'm for the petition in 615 and opposite party in 614.
that matter.
That matter, my lord. But your lordship heard this matter on the merits, but my lord, my learned friend raised an issue on the maintainability. And on that point, my lord, he was.
What is the matter?
Lord, this is a matter, my lord, relating to payment
Let
of
me see the
compensation under the National Highways Act.
Oh, he says section 34.
Order 9, Rule 13 was pending, my lord, against a ex parte decree. My lord, the reference, my lord, was decided on the basis of that decree, against which Order 9, Rule 13.
He says it has to be an appeal.
Yes. My lord, on that issue, my lord, I have.
Papered after 19 years. Appeal papered after 19 years. Section 5 papered just in the month of August 2025.
Appeal papered.
Order 9, Rule 13 is pending. He filed a caveat and that is, my lord, pending.
This is appeal preferred.
No, Order 9, Rule 13.
64. My lord, actually, in the year 2004.
May I place the case then?
All right.
Title suit papered.
All right.
Presently, my lord, this reference, if your lordship, my lord, may I
What
take
is the impugned order?
Yes, if I take your lordship to the impugned order, your
You are
lordship.
moving CO 704. 704.
Yes. Well, 704, my lord, kindly comes to the impugned order. My lord, this is, my lord, the answer to the reference, my lord, judgment was passed. Taking into consideration the decree passed in, well, a title suit number 64 of 2004.
No, so this is the judgment dated 22nd of December 2023.
Yes.
What have you done after this?
Well, I have preferred this revision before this court.
You said order 9, rule 13 and other
No,
things.
my lord, this reference, my lord, has been decided, my lord, taking into consideration the judgment and decree passed in a title suit number 64 of 2004, against which order 9 rule 13 is already pending. They filed a caveat and proceedings is going on.
Yes.
And my lord, this reference, my lord, when this reference is, my lord, decided, my lord, although my lord, document was submitted to that extent that order 9 rule 13 was pending and it has been taken on record, your lordship has also noticed that, my lord, in internal page 6 of the impugned judgment, serial number 14. Information slip dated 2/6/2023 in connection
Show me
with
the ex parte decree.
lordship.
Show me the ex parte decree.
Decree কি annex করা আছে?
Page 67, my lord.
67. I'm thankful. Page 67 onwards.
December 2008, and application papered in the year 2023 after
Because
16 years.
একসঙ্গে বলো না, এক এক করে বলি তো তুমি বলবে। Well, this 64 of 2004 was between Manoj Kumar Bhattacharya, my lord, and Gopal Chandra Bhattacharya and others. Tara Prasanna, my lord, we are the legal heirs of Tara Prasanna. Now Tara Prasanna died in the meantime. Thereafter, my lord, substitution was effected. But the ex parte, this order 9 rule 13 was filed by the substituted parties, and they have filed a caveat, and that is pending. My lord, may I sum up the facts of the case in a very short
Give me
manner?
a minute. Yes, but Mr. Rai, against this judgment, an appeal lies.
No, well, so far as this refers, but this impugned order.
Yes.
My lord, my humble submission before your lordship, my lord, this is an order, my lord, passed in connection with the statute, my lord, which is a final order, and against this order, my lord, only revision is maintainable. Yes, my lord, I have authorities on that. This was the, my lord, may I place?
This is under the National Highways Act.
National Highways Act.
So National Highways Act, it's an award.
Lordship, but section 3H4, if your lordship kindly take up section 3H4, the language of the
National Highways Act একটা দিন তো।
My lord, paragraph 3, my lord, this is one of the judgments, my lord, I have other authorities of other high courts also. Paragraph, my lord, your lordship is taking up the statute. PH4. If any dispute arises as to the apportionment of the amount, if any dispute arises as to the apportionment of the amount or any part thereof, or to any person to whom the same or any part thereof is payable, the competent authority shall refer the dispute to the decision of the principal civil court of original jurisdiction, within the limits of whose jurisdiction the land is situated. Then, my lord, 3H5 is regarding arbitration and all those things. Now, kindly comes to the judgment, my lord, which I have just now placed, my lord, before the lordship. Exact issue was a writ petition is not maintainable against apportionment orders under the National Highways Act. The proper remedy is to file a revision. This was the ratio laid down by the High Court of Kerala. My lord, paragraph 3, my lord, may I place it?
Yes.
Paragraph 3 says, my lord, however, learned counsel appearing for the revision petitioner in CRP number 748 of 2013, landlord of the property question, which is posted along with this writ petition, pointed out that the remedy of the petitioner is to file a revision in accordance with.
Where is the decision of the division made? It has only followed the decision of
Yes,
the
yes. But a division by decision, my lord, I could get, but I have the references of other high courts also. My lord, I'm placing it. Now, my lord, kindly, my lord, this is the decision of the Allahabad High Court. Anything?
Yes, Mr. Das, why you are saying that an appeal lies?
My lord, kindly consider, though it is National Highway notification has been issued under the National Highways Act, no doubt about it, but proceeding is initiated under the Act 1, 1894 Act. Kindly see page 10, internal page 2 of the order impugned.
My lord, may
No, please kindly come to section 3J of the National Highways Act.
Nothing in the Acquisition Act shall apply.
That is
Land Acquisition Act shall not apply.
Yes,
Nothing.
Yes, but
so if nothing in the Land Acquisition Act applies, so the provisions of appeal is a creature of statute.
But my lord,
unless the statute specifically provides for a right of appeal,
yes,
and Land Acquisition Act, right of appeal, it says Land Acquisition Act not to apply. You have an authority in your support
yes,
that.
madam, I have seen this. I have seen this, madam, but point is that when the proceeding has been referred by the collector, when the proceeding has been referred by the collector to the district judge, it has been noted that fact giving rise to such references that Government of West Bengal through the Land Acquisition Collector Bird 1 and acquired the land from the petitioners for the purpose of construction of road over bridge under section 4.1 of Land Acquisition Act 1894.
No, where are you reading?
Page 2 of order impugned. That is
page 2.
Page 2. Top. Now, what procedure has it for? That is the question, my lord. It is not a question of apportionment. It is the title of the parties. Page 2, top. The fact giving rise to such a reference is that the Government of West Bengal through the Land Acquisition Collector Bird 1 had acquired the land from the petitioner for the purpose of construction of road over bridge under section 4.1 of Land Acquisition Act 1894 on 29 October 2004. And point is that, my lord, the title of the parties, not the apportionment of about by the declared by the concerned authorities. Who is the owner of the property?
No, maybe. So show me the from where do you say that it's an appellable order?
Yes,
Statute National Highways Act does not say so. National Highways Act
26 subsection 2. What do you think?
Land Acquisition Act shall not apply, it has been said.
But my lord, proceeding is initiated on the basis of Land
No, no.
Acquisition Act.
No. So where?
That is,
That's the only the compensation, how it is to be computed, nothing more than that. It's a different procedure under the National Highways Act. What are you saying?
National
It's an
Highways Act.
award. If you want to challenge, it's an.
Section 18 reference and all those things are there.
Yes.
So now after
That is
the
there,
award,
but my
this
lord, they should have to challenge it.
apportionment, it is only with regard to that.
There's arbitration
Here,
proceeding will be followed.
It's an award which is applicable. In National Highways Act, it's not that award. Award is under 3G. So that has to be an arbitral award. Yes. So section 34, not in this.
No.
First. Second is, here it's a question of reference, proportion of the shares, not with regard to the award.
But
This
they
is
did
not
not
applicable.
actually- They did not raise a dispute regarding the compensation award. That is the title of the parties is concerned.
So if that is so, appeal one thing, but here it's not, it's only with regard to the apportionment.
Then my lord, I have no objection. Lordship can take it up.
Then, my lord, the other decisions I need not
No,
place.
only one thing, this order, this impugned judgment
Lordship.
is on the basis of the order passed by the title suit
64 of 2004.
But that decree is only on that basis this apportionment has been made.
Yes.
But that is order 9 rule 13 is pending.
Not
So
only-
how can it be given effect now?
My point is,
Not only that-
913 application filed in just 2 months before the order passed.
I'm directing the 913 application to be disposed of
Yes.
expeditiously.
Yes.
One
We
thing
will be
I have
benefited.
noticed, my lord. They filed in after 19 years. They filed.
Get it dismissed. Mr. Das, get it dismissed. Because this is the sole basis. That is what I was trying to find out. Please kindly come to the penultimate page of that impugned order.
Internal page 10.
The internal page.
It is not
10.
10.
Yes,
It will be 10.
Yes. Please see the last paragraph. In the application. Last paragraph of that page.
In the application, Manoj Kumar Bhattacharya.
As averred that he is the owner of such and such,
Because of-
but from the judgment and decree, it appears Manoj Kumar obtained a declaration of title in respect of 4 acres.
Yes, my lord.
And as such,
Yes.
4 acres only.
Yes.
So this by virtue of this decree, this order has been passed,
Lordship.
declaring in. Order 9 rule 13 is pending. So how can this be given effect?
Another suit is pending.
After 19
Appeal is pending before the DLRO.
Dismissed. Get it dismissed.
And another point, my lord, no, there is one more point. It is also very vital, my lord. The reference has not been completely answered. If your lordship sees the last portion, only
When did you file order 9 rule 13, Mr. Rai? With how many?
Order 9 rule 13 was filed.
How many days delay?
19
My
years.
lord, that just now, my lord, I have annexed the petition. But my lord, what happened here, my lord? My
Order 9 rule
predecessor-
13, you have filed your
Yeah,
objection.
he has filed a caveat. He has filed a caveat. He is already appearing.
But I am directing the order 9 rule 13 to be
Yes.
disposed of within a month.
Lordship.
Yes. What is the next matter?
Item number 1233.
And for the plaintiff petitioner, my lord.
Yes.
Plaintiff didn't have to shoot petitioner hearing.
What do you want?
My lord, challenging the propriety of the order passed by the United Trial Court on 19/2002 shoot petition in the entire shoot in order to substitute the that is why the petitioner has been
dated
19 May 2020, last page, my lord. 19 May 2023, my lord, whereby the learned trial court have passed an order on the ground that the defendant knows the death of the defendant has been known to the petitioner, but has come belatedly. But in a shoot, it cannot be, this legality and property cannot be sustainable ground. That is why I have challenged, filed this petition under Article 227 of the Constitution of India, my lord.
Rightly, if the suit has abated, you have to take steps for setting aside.
In a shoot partition, my lord, at a hearing, does not require under Order 22 Rule 10, my lord. In several orders of the Prasad, there is several orders and also the trial court on the discordant mention of the Calcutta High Court. There are so many judgments are there.
Where under substitution is not necessary in a partition suit. What are you saying?
But not just judgment of the Supreme Court. Shoot for substitution. When a petition has been
substitution application. Show me your substitution application.
Yes, ma'am.
Justice Dipankar Datta's judgment relies upon 2003 volume 10 SCC 691. That's the parent decision. That was followed in 2025. So please show me your substitution application. Let me see that none of those ingredients are there in this application.
Running page at 15, my lord. I filed it to shoot for substitution.
Yes.
Whereby
show me however you explain the delay.
My lord.
Show me however you explain the delay.
Defendant number 1 was passed away on 5th December, on 5th March 2019. Thereafter, I came to know on 11th December 2019. My lord, I filed the shoot on 11th December substitution. So substitution application, but substitution application has not been allowed. Therefore, I have come before this honorable court. Kindly pass an order whereby this shoot.
IFSC appears to this court that the petitioner filed an application for substitution after setting aside abatement, and the learned trial judge misconstrued the same to be a simpliciter application for substitution. Petitioner is directed to serve a copy of this application by registered speed post with acknowledgement due and file.
I served everybody, my lord.
Where have you
served
served?
Everybody.
When did you serve?
Pursuant to the earlier order of the Honorable Justice Vishwajit Basu, my lord. I served
Who is
everybody.
appearing for the opposite party?
My lord.
Who is appearing for the opposite party?
There are several opposite party here. Under 38 persons are
Did
there.
you give any notice to the opposite parties before mentioning for upgradation?
Lord, I have served everybody. And
sir, did you give any notice before mentioning for upgradation?
Yes. My lord.
Show me that you have served upon the opposite parties before mentioning for upgradation.
My lord, this is the affidavit service, my lord.
Sir, did you inform them prior to mentioning for upgradation?
One thing I am communicating.
Sir, I am asking you.
My lord, I am.
You have probably understood.
This is a change brief, my lord. I am saying the fact is that the person concerned who is conducting the trial court shoot, he has refused to answer anything.
You have to serve. You have to serve the parties.
I go to the trial court, I mean Barshat court, whereby I have searched. Nobody has responded. Who is the earlier person? That is why thereafter I have served.
Though
After
this
the order of the pass, this is the affidavit service, my lord.
If it is service with regard to compliance of the order, not for upgradation.
No, thereafter upgradation, I could not find anybody to receive my upgradation notice.
That's neither here nor there.
Kindly see the affidavit service, my lord.
This service filed in court today is taken on
It is
record.
not possible. Kindly listen the predicament.
Then, sir, you have to It has to be called on.
Senior citizen
Maybe.
lady is
Please don't
suffering, my
exhibit
lord.
your client in court. Please don't exhibit
Kindly
your client.
allow, my lord, kindly allow.
Yes, the learned advocate appearing for the
Continue, my
petitioner.
lord. This is my humble submission.
The
my lord.
learned advocate appearing for the petitioner submits that the opposite parties have been duly served. First up, every service filed in court today, file your every service. Every service filed in court today is taken on record. First up, on a query of the learned advocate appearing for the petitioner could not. This matter was mentioned for upgradation, citing urgency. First up, however, the learned advocate appearing for the petitioner could not produce any notice to show that that any notice was served upon the opposite parties prior to mentioning this matter for upgradation.
They have not received.
First up,
it.
petitioner is
They
directed.
refuse to accept it. Service, my lord.
Petitioner is directed. Petitioner is directed to serve a notice upon the opposite parties by raised a speed post with acknowledgement due and file an affidavit
My
of
lord, it
service.
cannot be complied, my lord, because of the reason the affidavit of service already they have refused, left the place.
Sir, did you understand what did I say here?
My lord, in that case,
Sir, this was appearing under serial number 1, 2, 3, 3.
Right,
So it has come at top. How do the other sides know?
my lord, because of the reason this legality and property has been challenged here, my lord.
Since I'm not inclined to the learned advocate. Sir, I'm releasing this matter.
Legality and property.
Sir, if you can serve, otherwise I will release this matter.
Your lordship knows very well. In a shoot for partition cannot be abated, my lord.
I have to hear the other side, sir. You are not understanding that.
They are not receiving, my lord.
Then you please wait till your serial comes. 1, 2, 3, 3. Please don't jump the
lady has been suffering, my lord. Since 2007, 2018.
This matter was appearing under item number 1, 2, 3, 3 in the category.
Kindly,
this matter was appearing under the item number 1, 2, 3, 3 of the combined monthly list. First up, this matter was mentioned citing urgency, and considering the urgency pleaded, this matter was upgraded. First up, however, it does not appear that any notice was served prior to mentioning for upgradation. First up, petitioner is directed to serve a notice upon the opposite parties. First up, list this matter in the monthly list of November 2025. Yes, next, call the list.
The predicament, my lord.
Sir, please serve a notice, it will be taken up. Yes.
Appear for the petitioner. My lord, on 7th of August 2024 and 2024 an order was passed. My lord, there are two suits. In one suit,
one thing, my lord. This is a change, my lord. Legal service. My name can I have already taken change.
File the Bakalatnama.
Yes, my lord.
Please give your appearance.
I have already. This is the change.
I am a tenant.
Can you take it?
Of my tenancy in 2018. In 2013, the landlord filed a suit for eviction. My eviction. I filed an application under section 24 before the district judge, my lord, for analogous hearing of the matter. A very innocuous prayer, because I believe, my lord, the prayers, my lord, of both the suits are, my lord, of the same issue, concerns the same issue regarding the same parties. My lord, the order was lastly heard, my lord, on 7th of August 2024, wherein Justice Bashu, your lordship, on the first paragraph itself.
No, eviction suit is the eviction of a tenant.
Yes.
And your suit is for declaration of tenancy, right?
Yes.
Mr. Mondal, what will happen? Let the eviction suit, because he is not disputing your, Mr. Mondal, he is not disputing your tenancy right. Once he has filed a suit for eviction, it goes to say that he has admitted your tenancy right. So let the tenancy eviction suit proceed.
Only, my lord, I have not filed.
What is the impugned order? What is the impugned order?
My lord, impugned order, my lord, dated 1st of April 2024. I wanted an analogous hearing, nothing else. Both that suits should be tried analogously, nothing else, your lordship.
What is the stage of your suit?
My lord, it was my lord fixed for peremptory hearing.
Peremptory, and what is the stage of the eviction suit?
Both the suits are for that. My lord, both the suits, my declaration suit and their eviction suit, both the suits are fixed for peremptory hearing. All I want is for, my lord, analogous hearing, nothing else. Well, it's a very innocuous prayer.
Have you informed them
Yes, yes.
prior to
after-
mentioning?
Yes, after mentioning.
Not after mentioning, prior.
That it was updated, it is running in the list.
Who is appearing for the other side?
No one appeared before this honorable court, my lord, they are.
I'm for the opposite.
Oh, very
Yes, Mr. Haldar. Yes, Mr. Haldar. Yes.
So far, my stage of my eviction suit is concerned, it is in the PH board. But so far, the dependent suit for declaration of tenancy right, my lord, I do not know. Please judge.
Yes, my lord, I am instructed that is also in the peremptory hearing court.
Let my lord, the suit be transferred to the court where my eviction suit is pending. My eviction suit is pending before the Lalit additional civil judge junior division additional court at Kerala.
That is my prayer. If your lordship kindly looks at my prayer at section 24 application, that is my
Your suit is pending before the
Lalit civil judge junior division additional court at Kerala.
civil judge
pending.
junior division. First additional court or only additional court?
Additional court.
Additional court at Shialda.
Shialda.
That is the eviction suit.
Eviction suit.
And the other suit is?
My lord, civil judge junior division second court at Shialda.
Both the suits are at the same stage.
So far, my suit
Yes,
is
ma'am.
concerned,
Same
it is in the PH board, but their suit is concerned.
Yes, ma'am. Same stage. Same stage.
You have not taken instruction, Mr. Haldar, with regard to this. Asun. This application under Article 227 of the Constitution
Should be expedited since it is in a peremptory vote, my lord. Peremptory state, hearing of the should be expedited.
You file an application, Mr. Halda. Not in this application. Yes, yes.
In this matter, I appear a lot on behalf of the petitioner.
Petitioner. Yes, what do you want?
Because in this matter, my lord, your lordship will kindly see that I am a Thika tenant and the plaintiff has filed a suit for rejectment under predecessor. And as far as my Thika tenancy is concerned, my lord, I will be taking before your lordship will just come to this from where I purchased this structure. And may I
So what happened? 151 application rejected.
Huh.
What was the 151 application?
what I placed before the court that I am a Thika tenant, so this ejectment suit does not lie under premises of this act. Where I have filed order 7 I have filed 151, all are been dismissed.
Order 711, by which order it was dismissed? Where is the order passed under order 711?
Order passed under no, that is not here. That I have not annexed because I have.
Where is the application under section 151?
Your lordship will kindly come to page, the last but one page, that is 11th of March 2024. Because where I have been asked to file the 7.3.
No, where is the application under section 151?
That is at page 71. My application.
Oh, you have filed an application for stay till the decision of the Thika controller. This application under Article 227 of the Constitution. Yeah. What is the prima facie document to show that you are a Thika tenant, sir?
That's what I was placed.
Ad hoc rent. Ad hoc rent payment.
And my deed.
Do you have a clear, sir, please hear me. Do you have a clear copy of that ad hoc rent payment with that stamp? Clear stamp. Please show me.
That is a page.
Stamp is to be legible, sir.
That is your lordship will kindly come.
Show me.
Page 58.
58.
Then you know.
Yes.
57.
No, sir. Stamp is not legible, sir. Stamp is not legible, sir. That is why I am saying. If you get a clear copy of that stamp, you will know what is the effect of your that deposit. Thank you, sir. This application under Article 2. Nothing has been done. 7C application only has been fixed for hearing. This application under
Pursuant to Lordship's direction on the on 21st of August.
Fixed matter.
What did I do on 21st of August?
Lord, not my matter.
Sorry.
Lord, it's 4 p.m. fixed.
Yes.
And for the petitioner, Lord, Mr. Mukherjee is opposing me, Mr. Devjit Mukherjee.
Where is Mr. Mukherjee?
Perhaps 3:30 he has left. Perhaps 3:30 he has left. Let him read his position here.
3:30, this is not sure 3:30.
Perhaps for 3:30 he has left, Lord. So let him mark 4 p.m. Take it up on Tuesday.
4 p.m. Monday?
Monday, yes. Monday. না না জজ সাহেব বসুন না আমাদের কিছু ইম্পসিবল জজ সাহেব বসলে আমরা করবো তুমি দাঁড়াও না বলছি আমি আসবো না জজ সাহেব বসলে আমরা করবো মামলা ইজি মানডে অন 4 p.m. I have no problem বলছি আমি আসবো না জজ সাহেব বসুক maybe retain his position later
12 noon on Monday.
Monday, yes.
Provided you bring Mr. Mukherjee.
Monday 1 p.m. Monday 1 o'clock, 2 o'clock, 3:30. Minor takes it up. I am here, Miller, to address the
12 noon.
4 p.m. Keeps it at 4 p.m. Miller. Mr. Mukherjee must have left today. So
4 p.m.
just Tuesday হবে রে বাবা Monday কোটি হবে না
Yes, next.
জসে মজা করছে চলো ওকে ডেকে কিছু দিতে হবে চলো
Yes, Mr. Bhattacharya. Non-prosecution.
Kindly come. That 1240 is there. If Mr. Bhattacharya is mentioning, Lord, yes, Lord. That is prior to Mr. Bhattacharya.
না না আমাদেরটা হবে এখন কাল
Monday
2 p.m. Monday 2 p.m.
Top of the list. All right. Mr. Bhattacharya, for me, I do not have any problem. It's your choice. You decide which matters to be kept where, but mentioning you will have to manage. Mentioning time every day, 10:30, come and manage. I do not have any difficulty. No, yes, I will indicate everything, but you have to come 10:30 every day and control the mentioning.
Delegation.
Any day, 10:30, 1:30, 2:30, anytime, any matter, you say I will fix that. But mentioning, come and manage.
Justice Kollanidhi Sengupta, at the time of mentioning, he used to delegate one of the present lawyers. You take charge today. You collect all the slips and hand over.
So you will take charge and full the authority.
Among the persons present on that particular day.
Today you are present. I am appointing you for
mentioning day. Today is not mentioning day.
Yes. No. I am appointing you for Wednesday.
Mr. Bhattacharya, most confident person.
My lord, item numbers 260 and 261. My lord, this is with regard to entering visitation, my lord, of the child.
261. Supplementary list, yes.
No, my lord, this is, my lord, appearing as 3 p.m. fixed matter. My lord, after 9 matters, the matter was supposed to be taken up. My lord has provided for, my lord, an interim visitation at Joy Krishna Library. My lord, the matter will come back to my lord. My lord, I will serve notice. My lord, I just want
Who is your other side?
Okay.
Now, what do you want?
My lord, I want the child, my lord, to be with me during puja, my lord, for 2 days. That was my prayer. My lord's desire was that my lord will consider this prayer, my lord, when the matter is
File
taken
an
up.
application before the trial court. Let the trial court consider.
That will never happen. No, that will never happen. That will never happen. My lord, next puja will come.
Difficult, Mr. Banerjee. Now I do not know.
But this is already appearing as a 3 p.m. fixed.
Monday, I do not know what will happen. So now filing is not top, Mr. Banerjee. That's the difficulty.
And I'll travel, my lord, your lordship, by mentioning upon notice, my lord, on Monday, Tuesday. But the father is really, my lord, a little.
Provided you can satisfy Mr. Bhattacharya, because
That
he will be in
can
charge
always.
which matter to be placed where.
But that I will convince him, my lord.
Your lordship, he has been granted an application without certified copy of the order. That he has been granted, but department is not accepting.
Oh, Mr. Molloy.
Today, where? Today কোথায় লিখছেন?
নামটা ভুলে গেছিলাম।
There were some illegible pages which has need to be typed by the department, your lordship.
What can be done? You will be annexing.
Affirmation has been done yesterday, but the department said, you know, there are some illegible pages, and there is written with 2 days.
No, Mr. Bolay Bhattacharya, in my matter is appearing on the other side. May the matter appear on Tuesday, subject to my lord's kind
It is appearing,
convenience. As 3 p.m. matter.
If you let it appear, bring him.
Very well. Very.